Somebody wants time, mention it in the initial stage. Once argument begins, we will not grant time. Okay? If you want time, you make mention, we'll consider that. That's the initial stage only. Once having argued, no installmental argument.
The Lordship candidate, see the order dated 17/11/2025.
17/11/25.
Here, the Honorable Court has already taken note of all the facts and lastly directed for formal instruction in this matter. May I place that order?
I am reading. We are reading. So amendment application is allowed by
that is already allowed, incorporated. But what happened here, I have put forth my case that on the ground of limitation only, Learned Tribunal has dismissed my original application.
What was the subject matter?
Well, subject matter that income tax officers, those who are coming from other regions to the Odisha region, they will not get their benefit of past service. Then on that request transfer, if somebody is coming from Delhi region to Odisha region, he will not get the benefit of his past service. Then, for the first time in 2019, Honorable Apex Court in the case of Prabhadevi has held that since that was the regular service and in the same department, that benefit is to be given to the persons. Then that, in fact, that judgment is in rem. So far as Odisha region is concerned, they have given the benefit to some persons, and when preparing the seniority list, giving that benefit, they invited application from the other employees. If anybody having any objection, let them to submit. We have submitted the application. That last date was, you'll also kindly mark the date. 16/9/2022.
16/9/22.
Yes. 22 was the last date of making objection, if any, by the persons, those who are aggrieved or those who are going to.
They did not file in time.
Yes, Lord. We have filed in time. But that was, they have taken up that issue and rejected the same on 14/10/2022. You'll also kindly take note of that date also.
Brother, are you ready in the matter?
The last occasion, your lordship directed regarding.
We are asking a question, simple question, which will admit binary answer, yes or no. Do you want time or are you ready in the matter?
If your lordship please to dispose of the matter, then another date may be granted.
Yes, after next 2 weeks, week after next, we'll argue the matter.
Yes, madam.
At the request of learned, are you CGC?
Senior panel
counsel appearing for the OPs. Come on, call this matter week after next. But in the meanwhile, counter, if any, may be filed, filling which right to file one stands forfeited, and petition averments may be taken with face value.
That one date may be
4 times. 4 weeks.
That date one.
It will come through. Yes.
Item 2. Item 2 first, please said lordship for us. Last of 2004 was there. Whether they 8. Terms of the
What is this matter about?
1,000 rupees. Here, matter lordship, action of a property due to non-compliance of the lordship, rest of the dues, they forfeited the entire amount.
Surfacey matter.
In fact, that does not suffice, lordship. It is pure auction matter, lordship. But the property involves, lordship, arising out of a surface proceeding, lordship. The property was seized by the bank and subsequently put to auction. I was the auction purchase, lordship, and pursuant the auction conditions, lordship, I have deposited 25%, lordship. And the rest 75%, I could not deposit due to some problem, lordship. That's why they, without my knowledge, they went on to re-auction, lordship, and they put it in a higher price. And also the money deposit 20% deposited by me, that is forfeited without any law, lordship.
When first one is first auction took place when?
That's
auction was held. You came running to the court.
In fact, lordship, there is no vehicles available.
10 minutes, 15 minutes, we'll call it. Sir,
Lordship,
we just make a chit of notes.
Lordship, that full chair.
Pass.
Item 3.
Yes, please.
Forum there was the opposite criteria. The railway authority has filed a case against the order of Lawrence Central Administrative Tribunal. This is a matter regarding the pension matter. With this new pension, old pension, claiming for old pension, and the tribunal has allowed.
Sir, kindly use the mic. Mic, kindly use it. Yes.
The tribunal has allowed to the petitioner for granting the old pension and basing on the order of this Honorable High Court in Subodh Kumar Naik's case. And then the department has approached this Honorable Court. This case is admitted by this court, pendants of the Subodh Naik case in the High Court. And ultimately, Subodh Naik case, the court has, Subodh Naik case in this court, in CAT order against the department has filed a case. And by aid of that case, because CAT has allowed it, and basing on that, CAT has further allowed my
Your
case,
application.
my application. Meanwhile, Subodh Naik case is pending. That's why this court has admitted the department case for adjudication. Meanwhile, Subodh Naik case has been already been decided by the Honorable Court
In
favor. That is the only third point.
Is it true?
Yes.
Then nothing remains.
Nothing is there.
Give Subhadra Naik judgment. When you had filed
Yes, I have
petition,
Yes.
this case was pending.
Yes. That is the pending matter. When I filed the case, that is the pending matter. So in the meantime, that case has been disposed of.
Therefore, nothing remains.
And the operating person is page 6, my lord. Page 6.
You are Union of India
Yes, my lord. Remember.
and other officers. Which are the other officers?
All the officers.
Union government and its officials are knocking at the doors of Red Court for assailing the order dated the date of the CIT order.
There is no
25/4/2024, whereby OP's OA number 109 of 2022 having been favored, relief has been accorded to him in the following terms. Operative version of the order. Next one. Learned counsel for the OP submits, and learned CGC appearing for the petitioner, Union government does not dispute that the relief has been accorded to the OP by the Central Administrative Tribunal so and so, keeping in view, full stop, has been accorded to the OP, and that the petition has been admitted in the light of another cognate case in WP number 22554 of 2024 between Union of India and others versus Subodh Kumar Naik, decided by a coordinate bench of this court, wide order dated 15/12/2025, supportive of case of the vote. First one, any SLP etc. is filed against this. On being asked, learned CGC in all fairness submits that the decision in Subodh Kumar Naik has attained the finality, there being no further challenge thereto in the apex court. First one. Next one. It has been a cardinal principle of adjudicatory process that like cases should be decided alike, and therefore what has happened to Subodh Kumar Naik case should come to the rescue of OP hearing on the principle of verity, no derogatory, no inconsistent factors coming from the record. First off, next paragraph. In the above circumstances, this petition being devoid of merits is liable to be dismissed, and accordingly it is, costs having been made easy. First off, what was the time given in the earlier, before the 60 days? The petitioner shall implement the order, the impugned order of the Central Administrative Tribunal within an outer limit of 60 days and report compliance to the Registrar General of this court, failing which, in the next level of legal battle, heavy costs payable by the officials in their personal capacity may be passed, in addition to other punitive action. Yes.
Item 4.
May I please, ma'am?
Yes, sir.
This is a case relating to grant of financial operation under Assured Career Progression Scheme, my lord. This matter is covered, and this matter was before my lord on 3rd of December 2025. And my lord has passed an order, my lord. The opposite parties, they have to carry out my lord, the lordship's order. And further, in compliance to my lord's further order dated 15/12, I have filed a memo along with orders of this honorable court, order of honorable apex court.
Madam appears for any of the parties.
Lordship, I am appearing for the opposite parties.
To the memo.
Memo already in the record, my lord.
Yeah.
At Clark B.
Is it, who appears, who is your opponent?
Government of India. My lord appearing appearing through BC, my lord.
Your Lordship, I am appearing through BC.
Covered by the judgment.
Your Lordship, that has to be verified, Your Lordship. On the last occasion, my learned senior has served a copy of the petitions, Your Lordship. The counter is ready, Your Lordship. Because of the volume of the year, I have not been able to verify the documents, Your Lordship. I'll file the counter in the next occasion, Your Lordship.
All right. 2 weeks, finally, at the request of learned CGC.
Yes, Your Lordship.
CGC. First, it is open to the government to file counter if any within the said period, failing which petitions the right to file one stands forfeited and petition amendments may be taken up with the face value.
Great.
Next.
Item 5.
Lordship, Mr. Amitabh Das was supposed to argue this matter, but due to some personal difficulty, I pray for some time.
25 matter. But on personal difficulty of arguing counsel appearing for petitioner. Petitioner. Come on. Case is adjourned by 3 weeks. Finally. Next.
Item 6.
Item 6, my lord, for me to withdraw, my lord.
Tell the WP number.
34415, my lord.
Why not happy with the court?
No, my lord, that in meantime, we are applying for bank is not considering my application for
Do
settlement.
you have
my
a
lord.
memo
Yes,
to that effect? Give it. Learned counsel for the petitioner seeks leave of the court to withdraw the petition with liberty to pursue the remedy elsewhere. First off, memo reads as a, so this effect he has filed a memo which reads as a, first off, in the above circumstances, petition is disposed of as having been withdrawn with liberty as sought for. Next.
Item 7.
Item 7, your lordship, taking up after launch, your lordship.
After lunch, pass over you want. Pass over.
Item 8.
Yes.
I filed a I for correction of my prayer person, my lords. Amendment, my lords.
So you want amendment?
Yes, my lords.
What is the amendment you have sought for?
No, that is the consolidated prayer person. It's a file copy.
So the notice was issued to other side.
No, but till date will notice it notice.
No notice is ordered. It is post-notice amendment or a pre-notice amendment?
Pre-notice.
Pre-notice. This petition in the preliminary hearing list has the specified prayer. First, at the pre-admission stage, an application is moved seeking which is that application of IA 23571?
Yes. 23571.
An application is moved seeking leave of the court to amend the pleadings in the petition. And the proposed amendment in the said application reads as under. Okay, one is proposed amendment. Fine. Next one. Learned counsel for the petitioner submits, and we agree with the same, that the amendment is innocuous and it is at the earliest stage of proceeding, and therefore the same is entitled to be allowed. First, ordered accordingly. First, amended petition to be filed within 2 weeks. All right?
Yes.
Yes.
Item 9.
Item 9 was I'm for the petitioner. Let's here I'm praying for some time to file an amendment. Let's similar matter.
Want to amend the petition?
Yes, my lord. Some portion of the prayer and the
Counsel for petitioner seeks a short accommodation to come out with an amendment application in the fitness of things. First, call after 3 weeks.
3 weeks.
Great friends. Item 10.
Item 10, my lord.
Yeah.
Here the bank is before your lordship challenging the inaction of the CJM in passing final orders under section 14 of the Surface Act.
Which is the judgment of the apex court?
My lord, I have, and if you my lord, the entire judgment of the
Too many judgments. No, there is latest judgment.
only the point of law, my lord, I have given various judgments. And your lordship,
We have decided similar matter. No?
my lord, here also in the lordship, this honorable coordinate bench has passed certain directions relying on one of the judgments given by us, my lord, in the series of matters which were tagged together.
The last week,
So I only pray, my lord, based on that, let the final order be passed. I must My lord, I must point out in all fairness one more thing to your lordship. These are the judgments where I have given, my lord, where I have flagged the portions where the Honorable Apex Court has held that the section 14 power exercised by the is a ministerial act. It does not need adjudication.
What brother Dash?
Yes. But I must point out one more thing to your lordship, my lord. What has happened after we filed the OA and SA before the Debts Recovery Tribunal, we approached the CJM. Your lordship knows for physical possession, there is a provision called section 14 under the Surface Act. We have to approach the CJM. There is a 8-point rule which is given. CJM, I bow down, my lord. I am corrected. So what has happened? Thereafter, they have filed certain petitions in the NCLT, which are pending adjudication. So, my lord, there are various provisions which a guarantor and our loan can file. One is under section 10.
That NCLT is under ABC.
Yes. So, my lord, I have given that judgment also that the State Bank of India, when the loan is filed and if there is no order of moratorium, that will not apply.
2017, Justice Nariman's judgment.
My lord, it is 2018 7 SCC.
Justice Nariman's judgment.
It is flag B, my lord. There are series of judgments are there, my lord.
No, read that judgment. That is the principle.
Yes, Justice Narayan, I bow down, my lord. The Justice Narayan. Yes.
Who appears for the other side?
So what I was saying, my lord, my prayer before your lordship is innocuous. Let the CJM pass final orders. I am not saying, your lordship, now the stage has not come that I will adjudicate that the CJM has passed some order on merit, which I am testing before your lordship.
Who are parties to your petition?
My lord, the parties are, first is the CJM, next is the loanee, the others are the guarantor and mortgages.
Then notice has to.
No, my lord, it has to be disposed of simply. I am not.
Why you have implemented them?
My lord, because they are parties there, they are appearing there.
The objective.
My lord, your lordship, kindly see, lordship has passed 2 orders also.
I know, but the objective is.
My lord, there is no adjudication.
You don't want to give opportunity to the.
No, they are appearing there. They are aware.
Listen or not? My lord is saying something. Would you listen or not?
I'm extremely sorry. I'm
Give opportunity to the judge to say something.
I'm extremely sorry. I'm out. I'm sorry.
Why have you arrayed the loanees as parties?
Loanee, guarantor, mortgages are all parties.
Why you have arrayed them?
Because if your lordship raises this issue of them, unless I party,
the object of making them parties to give an opportunity of hearing to them.
My lord, what I was suggesting to your lordship is, my lord,
issue emergent notice returnable within.
My lord, what instruction I received, the CGM has kept it posted today for orders. So if your lordship may, if the CGM has passed orders.
Let notice go in the meanwhile. Because again time will be spent.
Well, I am received.
Next.
My lord, item 11, same.
Same, call along with each other. Week after next. Yes.
Item 12.
In this case,
There is a judgment.
I have filed this application, interim application for intervention.
For withdrawal.
Intervention.
Intervention. Impleading application.
Here,
My only small prayer, lordship, direction was given to early disposal only. I am prayer, lordship, in this petition only for early disposal.
Early disposal of what?
This case petition pending before the CGM under
14.
14 of the Surface Act.
14. And who are you?
I am the legal heirs of the mortgage.
Yes.
My lord, 13-2 notice was issued. Thereafter, the mortgagor expired. Without issuing any 13-2 notice, they issued possession notice. That was challenged before the DRT. In DRT, they have also filed a recovery suit. There they have impleaded us. They filed one section 14 application before the collector. While that was pending, they filed an application before the CJM for self-relief. When we pointed it out, the Lord CJM rejected it. By suppressing everything, they have filed another application before the CJM. Now, the thing which cannot be done directly, my friend is trying to do it indirectly. Because when their case is involves suppression of fact, here also they have not disclosed that earlier they filed 2 section 14 application.
They are rejected on what ground?
My lord, one, they withdraw it. Second, because they suppressed the material fact that the earlier, before approaching the CJM, they filed application before the district magistrate. On that ground, it was rejected.
Because now the district magistrate will proceed.
No. Self-same relief. Again, they have approached the CJM.
No, there is no res judicata for 14.
Saying any res judicata.
Any number of applications can.
I am not saying any res judicata, but at least they have to disclose at least before this honorable court.
So they cannot take possession at all now?
No, I am not saying it. I am not saying, my lord, in section 14, after amendment, that is after 15 January 2013, either the district magistrate or the chief judicial magistrate has to verify the affidavit, 9-point affidavit, and he has to record satisfaction. Thereafter, he will pass the order. Here what has happened? 13(2) notice was issued to the mortgagor. She expired. Whether the legal heirs are entitled to get any 13(2) notice or not. If 13(2) notice are not issued, then Section 14 application will not be maintainable.
Whether you are before the DRT now?
DRT bank has gone, we have gone.
You have gone for what?
We have challenged their action initiated under SARFAESI without issuing us any notice.
Is it stayed?
There is no stay.
Then you have no.
Because time.
That's all. You have no.
So far as the property is concerned, it is a leasehold property.
What you read? Leasehold property is also property for the purpose of mortgage. A leasehold property can be mortgaged.
Subject to permission.
No,
Yes.
you are there for the
Here, the property is leased out by the Bhubaneswar Development Authority. In the lease deed itself, there is a clause that prior permission is required.
You argue that before the DRT.
That is all because the moment will be dispossessed.
We do not. No, that you get it.
So,
state. You get it stated.
Before the magistrate, they have also made us parties.
All right.
Here they have not made party. Your Lordship, kindly see the writ petition.
Yes.
And I have enclosed entire records.
The question is not that. The power of the writ court is coextensive and coterminous of the authority whose proceedings are being examined.
I have not done that, my lord.
We are telling you now.
My lord, since the matter is pending before the day,
you get stay there.
No. Since the matter is pending before the Chief Judicial Magistrate, since he has filed this petition, there they have implemented of such party. Here they have not implemented of such party. That is why I have filed intervention application. Your Lordship, allow my intervention application.
No, we don't think that you are a necessary party in the light of apex petition in Rajia Begum versus Shahnaz Begum.
Interest of the property.
You may have interest. Before the court, before the DRT, you go and press your petition. And if you succeed, then get the stay. All this will be stayed. You need not be made a party at all.
Neither the CJM is in a adjudicatory procedure.
He has to satisfy.
No.
He has to record his satisfaction. I will satisfy your lordship.
To record his satisfaction with regard to the section 15.
That's all. The satisfaction. Your lordship, kindly see, I have prepared. No. Lordship, kindly see. In 2013, after amendment, first judgment is the Noble Aqua case.
2013 or 2023?
My lord, amendment was in 15/1/2013.
What is your proposition? What is your proposition? Tell me.
My proposition is the CJM or the district magistrate.
Right. Tell it. Right.
But my submission before your lordship that the CJM or district magistrate has to hear the borrower, and the documents which will be filed by the borrower, that has to be verified. After that, after recording satisfaction, the authority has to pass the order either way.
What is the satisfaction?
Satisfaction 9-point affidavit. 9-point affidavit along with section 14 application. Your lordship, for a moment kindly see section 14.
Yeah.
Earlier there was no provision for issuance of notice. Only they have to verify whether the property situates within their jurisdiction and the 13(2) notice is served or not. Your lordship, kindly see section 14. That is first proviso, provided that any application. Your lordship got it?
Yes.
First proviso, provided that any application by the secured creditor shall be accompanied by an affidavit duly affirmed by the authority officer of the secured creditor declaring that is 9-point affidavit, aggregate amount of financial institution.
Have you filed the, please alert me. Have you filed affidavit?
Yes,
9-point affidavit? Have you
Yes,
filed?
yes.
Where is that copy?
They have not given me.
No, that part I'm not giving. I'm only giving the petition.
In the writ petition
I'm
also
giving only
they have not
petition.
given.
Have you filed that affidavit?
Yes, Lordship.
Where you have not produced it here.
Lordship, before this only I'm only filed the petition, Lordship. The affidavit I have not filed.
No, you have to, suppose if you need any help, assistance of the court for enforcing the provision under 14, then you have to tell what all you have done before the court below. Otherwise, how we will know?
The necessary compliances before the court has to be before this court for appraisal. Otherwise, how can we appreciate?
That's what. You produce that
sorted, I've filed that.
Petitioner to produce 9-point affidavit under the provision to section 14. 14. First one. Tomorrow?
Day after tomorrow.
Day after. Third day after.
Another point. My friend has
let him come. Let him come with the affidavit.
Has filed the petition
Next.
for direction to dispose of within a specified period.
We are posting this matter day after tomorrow.
It means Monday. Or the next working day.
We can call it Monday. So, yes, next.
My memo kindly be kept on record. I have given the citations.
Item 13.
Right. See, is for condonation of delay in the filing the appeal. But definitely, my lord,
how many days of delay?
My lord, my lord, initially there was no delay, but after this second reporting, 200 some days, that only ground is, my lord, we have filed a review against the judgment within time. 30 days the time. Review was dismissed, and after the dismissal of the review, we filed within 30 days. So that is within the time. That is why the court only technicality.
My lord, I am for the state.
Lords, I am responding.
Any private parties?
Yes, Lords.
Yeah.
I'm filing the objection post of the day, Lords.
When the application was given to you?
They have taken twice, thrice time.
You can't play with the court that way.
No, Lords.
When the
I'm
application
talking
was
the
given
copy right now, Lords.
application was given to you when? In this only we are spending time. We are criminally wasting time of the court.
No, Your Lordship. I apologize for that delay.
We don't apologize. We don't want your apology. We are asking you when the application was
Lord, the application, as per my knowledge, 4/2/2025.
4/2/25.
Lordship.
How many months have elapsed now?
Lords, after that, twice the matter was listed, Lord.
It should be listed.
Lords.
Failing.
No, Lords. I am filing. In the course of the day, it is ready. I am serving the copy on my London Stadium, Lords, right now, Lords. Let the matter posted the day after tomorrow or on Thursday, Lords. It will be heard and disposed of, Lords.
That delay we shall condone.
Lords, there is a delay of 252 days, Lords. That, on that part, it is to be heard, Lords.
I am hearing you.
Lords, Lords, let that objection come on record, Lords. On that day, Lords may dispose it of.
It is not there on the record.
No, Lords, not yet filed, Lords.
You are not taking your objection at all.
Lords,
because you have taken 1 year for filing the objections to the application. Your rules provide only 2 weeks. Under your rules.
Done, Your Lordship. Bow down, Your Lordship, but
then agree with this. Application is filed seeking condonation delay of 252 days. First of the said application is being supported by the affidavit.
No, you are also aware that the review petition was pending and it was disposed of after that outcome.
That's the only correct.
The matter
appears to be sufficient in as much as the review petition was pending against the order in question. First of this apart, 11 months are over. About 11 months are over. No objections are filed to the application. When the extant rules of this code describe a period of 2 weeks for filing the objections. First time. in the above circumstances, continuation of delay would not cause any prejudice to anyone, in as much as matter would be heard on merits, giving opportunity of participation to all the stakeholders. First of all, non-continuation would oust the petitioner out of the court, and that is not desirable. First of all, in the above circumstances, application having been favored, a delay of 252 days is condoned, subject to petitioner presenting which book you will present to the library.
Any book, my lord, any book suggested by my lord.
By Rama Joy's service under the state, subject to petitioner presenting Justice Rama Joy's magnum opus, service under the state, services under the state, to the library.
Bar Association.
Within two,
Bar Association.
Within 3 weeks.
All these cases, my lord, out of one judgment, all these batch of cases are out of one judgment, one recorder, everything is one. Same employees of the same institution. All common order, my lord.
Common order.
Delay period is different. 50 to 32 delay period is different.
The delay period.
Only one book, my lord, because they are same poor employee, not getting. All the case, only one order.
One.
Lords, there is another thing, Lords. In the second sub-item, Lords, in the second sub-item, there is a notice could not be issued to the respondent number 5 due to non-filing of requisites. There is a noting, Lords.
67 of 24.
Lordship. 67 of 2020.
He has appeared. My learned friend has appeared.
I am appearing for respondent number 4, my lord.
Respondent number 4 is private party.
Yes. Yes, my friend is appearing. What?
Mr. Panda accepts notice for 1 and 2.
1 and 2, my lord.
Note emergent notice to 3.
3, my learned friend is appearing.
Yes, as per noting, the respondent number 5 notice has to go, Lord.
There is no 5. There is no 5.
But noting shows that there is a...
It is 3.
67.
Pragyan Paramita Jethi.
Yes, Lord.
Oh, notice has to go now.
Second, yes. But here's a case in the page. I will take instruction. Some miscommunication.
And then application has to be, now order has to be recalled. That only in a matter, in the first matter, that order can be made.
No, all other cases, it has this particular case, that's retired or something like that, for which no
Lordship may find
delete the name.
Lordship will
find confusion with the because I have not gone.
This is only in 67 or any other matter?
67. Lordship may look into Lords.
3 matters.
All other same.
There is a writ appeal number 100 of 2024 that he is the appellant. My learned senior is appearing for that party, Lords.
Yeah, that is why we are saying it is not required.
Let him take
format party, normal party. That is why I am saying, these are the pro forma parties. And same employees.
That is second. The OP number 5 in 67 is appellant in
another one case, Lords.
Another case.
Lordship.
I am there.
He is appearing.
I am there. That is pro forma party. They are selling the same. That was wrongly made a party. That is why I have been making a party.
You appear for both petitioner and OP.
That is opposite party. They are same. They are same putting. Some mistake. That is why I have said.
You verify, brother.
I will verify that.
That will verify. So we granted at the request of counsel for the petition. Yes.
Item 14.
May I please, your lords?
Yes.
My lord, there is an amendment petition that is flag B, my lord.
Amendment to?
My lord, amendment to read appeal, my lord.
Amendment to the petition?
Read appeal, my lord.
Read appeal?
My lord.
What is that amendment?
My lord, that amendment that so inadvertently I have not annexed some document, though I have taken the plea in my read appeal, my lord.
In the petition it was there?
My lord, my lord.
You filed document IA.
My lord.
Where is that?
My lord, that IA
It has not
3179 of 25.
This is a like order. Because they can pay the.
You have already filed IA.
My lord,
It has not been brought on record.
My lord, that has
When will you
already.
file?
My lord, that was allowed, my lord.
Allowed also.
My lord, that if your lordships kindly order dated 1/9/2025, my lord.
5. Put 1925.
Order number 4.
My lord.
Yes, appeal to be amended.
My lord.
Have you amended?
My lord, I have already consolidated copy, my lord, that I have filed on 15/9/2025.
The consolidated appeal memo has already been filed.
My lord.
What is the appeal?
My lord, appeal is against the, if your lordships, can I pray for some time, my lord?
No, it's a request of petition. They given in admission if you see time. How the court should work. Yes.
Item 15.
May it please the court. Your Lordship, this IA is filed for condemnation of delay. The delay is for 2 years and 3 months, Your Lordship.
2 years, 3 months.
Yes, Your Lordship.
What is the order challenged here?
So the order challenged here, Your Lordship, is that I had prayed for, approached this Honorable Court with a prayer to remove the electricity pole which was erected on my property.
In your property?
Yes, Your Lordship. Electric poles and electric lines which pass over my property. As a result, I could not construct my house.
On what ground learned single judge dismissed the petition?
The learned single judge dismissed the petition. If Your Lordship, page number 12, Your Lordship. The dispute arises.
Dispute arises by you for one number of poles, which is of the above floor.
At this stage, we'll change the total alignment.
Yes.
But they are using your land.
Yes, Your Lordship.
How can learned single judge say this? It is his land.
Yes.
Take notice.
Yes, Your Lordship.
Issue emergent.
Your Lordship, Mr. Sesu has been replaced with TPCODL and Mr. Lalit Maharana appears for
TPCODL. Who is the party?
Sesu is the party.
Yeah.
Sesu. Executive officer.
How can it be? You have to amend it. TPCODL has already taken over.
Yes, Your Lordship.
Sesu is no more a party.
Because in the writ, Sesu was a party, hence.
So you have also made TPCODL a party.
No, Your Lordship.
Number 4.
That party also arena.
That's there already.
Opposite party 4. Yes, Your Lordship.
Party 4 is there.
Yes, Your Lordship.
Then you take notice.
Yes, Your Lordship.
Take emergent notice that in in 4 weeks. Yes.
Oblige, Your Lordship.
Both on petition and I. Next.
Item 16.
Item 16 on behalf of my senior, I seek for Passover.
Passover. Passover.
Item 17.
17, my lord, I am appearing for respondent. The very important judgment under challenge has been challenged by the state. That has been dismissed by the division bench of this honorable court. The very common judgment of the honorable single judge challenged by state has been dismissed. And the Court of Municipal Corporation has filed this repeatedly challenging that judgment.
It is dismissed on what ground?
Your Lordship kindly see. Judgment. 2 copies I have filled.
You are for.
I am for the respondent.
Respondent for the appellant.
So writ appeal is considered or
The Lordship may dispose it on the light of that writ appeal number.
I will give it 693 of
2025.
And Your Lordship, delay may be.
In that case, delay also condoned.
An application is seeking condonation of delay supported by affidavit. First one, no objections are filed by to the said application rightly. First one. What is the delay?
Delay is 139 days. 139 days.
Delay is 139 days. A plausible explanation is offered for the same. First one. Ordinarily, short delay is condoned by the courts, lest justice be done. Lest justice be done. First, non-condemnation of delay would put the party to hardship and injustice arguable. First, Next one. Learned counsel appearing for the OPs very fairly submits that application be allowed and delay be controlled. First, next in the above, but this one, the application having been favored, delay proved in filing the writ of bill stands controlled. First, next one. Learned counsel for the OPs submits that the subject matter of this petition is substantially similar to the one in writ appeal number 693 of 2025 between the state of Orissa and others versus Commissioner, Conduct Municipal Corporation and others, wherein the petition of the kind has been negatived by the coordinate bench. First one. Next paragraph. In view of the above, this petition also has to meet the same fate, and accordingly, in terms of the order in the cognate case mentioned above, petition is disposed of. Yes.
Item 18.
My lord, it's a intercourt appeal, and in pursuance to your lordship's order, so far the limitation is concerned, we have made the deposit as per the order of this honorable tribunal, and that has been taken care of by this court.
What was the amount deposited, ordered to be deposited?
Yes, madam.
328 days in filing the appeal.
It is 328 days, madam. That we have deposited, my lord. Kindly have a glance to the order. Dated 12/12/2025.
Order of the Honorable Chief Justice and Companion Judge.
Yes, ma'am. That we have made the deposit before the legal service authority.
212.
Yes, ma'am.
1 lakh rupees you were directed to pay. You have paid it. When did you pay?
My lord, I am giving the copies.
Do you dispute that proposition?
No, because the amount is not paid to the respondent, paid to for noble cause is their lordship are there.
That was directed to legal.
So I don't know whether the representative that is not within my knowledge.
Legal service authority, we have obtained the receipt, my lord.
Yes, perfect. Next one.
Your Honor, the writ application was disposed of on 25/2024. It is available at page 37 below.
What was the subject matter?
Subject matter, my lord, the petitioner was working as a DLR in the year 1995. TLR
means
NM and nominal master roles and daily wages. Working since 95. That is not. Subsequently, he was brought over to the work charge establishment in the year 2011. The date is 18/1.
18/1?
2011.
He gained entry to the position in 2011.
2011.
Yes, DLR.
As work charge establishment.
No, at work charge.
DLR under the work charge establishment.
So the establishment was work charge as well.
Yes, ma'am. And subsequently retired from service on 30/4/2024.
34/24.
Yes, ma'am.
That is 13 years, about 3 months.
3 months. And after retirement, filed this regularization of his service. While considering the same, the Honorable Single Judge passed the order on 25/2024. At the stage of admission, my lord.
That was in the case of Pradeep Kumar Panigrahi.
Right. Pradeep Kumar Panigrahi taking. But therein, we have not been filed the counter nor anything. At the threshold, my lord, on the same day, this has been disposed of. Stating therein, my lord, and have a glance to the operating part, my lord. May I have the 42 page?
I don't read the entire para 9 itself. Page 41, para 9.
Para 9.
Yes.
I'm reading it before that. Taking into consideration the factual background of the case and keeping in view the position of law has been analyzed herein above. This court deemed it proper to dispose of the writ petition at the stage of admission by directing the opposite party number 1 to consider the representation of the petitioner under Annexure 10 within 2 months from the date of communication of a certified copy of this order by the petitioner. Further, the opposite party number 1 shall do well to consider the representation of the petitioner in terms of the analysis made hereinafter as well as in terms of the order passed by the division bench in the court of Pradeep Kumar Panigrahi, State Supra, and the representation of the petitioner shall be disposed of by passing a speaking and reason order within the aforesaid time stipulation. In the event it is found that the opposite party number 1 that the petitioner's case is similar to Pradeep Panigrahi case, and in absence of any legal impediments, the opposite party number 1 shall
the pension, etc. Okay. Suppose if time was given to you, what could have been your objection? Show it from your appeal.
Yes.
How fate of the case would have been different if you were given time to file objection.
My part limb of my submission, so far the ground I have set forth. That is, so far at the initial stage of admission, this has been disposed of.
Did you object to that?
Yes, my lord.
Did you object to that?
My lord, why I am objecting, my lord? After the amendment of the pension rules.
No.
Did you object before that?
Did you tell the learned judge, kindly do not dispose of this matter, give us opportunity to file our objections, then you decide that.
Well, that has also been objected, but taking into consideration the learned counsel appearing for the state argued this matter. That has been well reflected.
Where is it objected? Where did you seek time to file objections?
You argued means you participated.
Yeah.
Why participated? At the threshold it has been disposed.
What is wrong?
Coming to the other part.
No, that goes to the maintainability itself.
Maintainability.
On that ground, you cannot maintain the petition. So first ground goes now. On merits come now.
On merits. So for rule 18, may
whether in the bar is there any hesitation of telling the court, no, don't dispose of till we file objection? Is it there? I don't know. Because in Bangalore, where from I come, lawyers will openly say, no, don't decide this matter. Kindly give us time. We will file objections, hear us, and then decide. Whether that course is open here.
Yes,
that
course is always open.
My lord, High Court rules is concerned.
And yet, the State Council has made its submissions also.
Chapter 15 is there, my lord. I can have the right to pass file an objection. Apart from that, so far the merit is concerned, so far the entitlement of pension of this DLR, NMR and work charge employees concerned, after due amendment of the rule of 92, well, there is a date, so far the 1/1/2005 is concerned.
1/1/2005
From 1/1/2005.
New pension bill.
The expension became
so that's in itself has got no provision for pension.
There is no provision for pension. Rule 3 clarifies. May I read, my lord, in pension rules?
Yeah.
3 is the application. Save as otherwise provided in these rules. These rules shall apply to government servant. Appointment in the post and services in connection with the affairs of the state, which are born on pensionable establishment, but shall not apply to Romanic A, persons in casual and daily rated employment, persons paid from contingencies, persons entitled to benefit in the contributed provident fund, members of All India services, pension employed on contract except.
Which clause is applicable? You need not read
Millard, A and F. Millard. A can have a glance.
A and F.
Yes.
A and F of
Section 3, Millard. Page 27, Millard.
This is you are reading 92, no? Pension rule 92.
No. This is the book, Millard. If Millard says, this book, then it will be convenient.
Yes, it is them.
Can have a glance to page 27.
Exactly.
It will be convenient.
Yes.
This rule will not apply to casual employments.
This person.
Like the rate petitioners.
Rate petition.
Person in casual and daily rated employment. whether your client was Mr. Mishra, whether your client was in daily rated establishment.
Yes, yes. Deleted establishment or coming to Vacha's establishment. All these contentions have been noted by the Honorable Court in that Pradeep Panigre case, and it has been confirmed by the Supreme Court.
This aspect is already treated.
It has been treated by the Supreme Court.
But that has not been raised at this point of time.
And has been implemented also.
That was my humble submission.
That was implemented also. Exactly, the facts are exactly similar. And in because in that case, what happened? The Honorable Division Bench said that for the purpose of reproduction, for one day, the supernumerary post will be created, and for that you will get minimum pension. That is the observation of the direction of the Honorable Single Division Bench of this Honorable Court, which has been confirmed with the Honorable Supreme Court. Not only in one case, there are several cases. Not only in one case, several cases are there. Only for to cut short the volume of the, we have filed only one judgment. But you have got several other judgments.
Where this contention is considered.
Contention is considered, my lord?
No, not considered.
No, that has not been considered.
No, this contention there has not been there.
It was not raised at all.
Only those cases it is not raised.
No, those cases they were not raised that point.
In
right?
this case,
other cases, my lord, other cases, their point was raised and this also decided. The other cases are there. I will bring to lordship other cases.
The question is whether this point was considered in.
Yes, my lord. Yes, my lord. This aspect has been considered.
That identical aspect, that argument is also considered.
Yes.
Considered.
Yes.
You are appealing from other
cases are there. Hundreds of cases have been disposed of in that manner, are pending also. Recently also hundreds of more cases who dismissed their petition on the other. I could do that again. This aspect they have been continuing again and again in all the cases.
It is considered that point.
So far the present writ appeal is concerned. But in this particular judgment, so far the Pradeep Panigre case is concerned. This has not been considered. Only in the light of that, this has been disposed of with an observation that to consider the representation and
that's all.
That is.
Consider the representation.
But actual aspect, so far the DLR and workshop establishment is concerned in 2011. If 2005 the new
whatever decision you want to take, you take that decision in the light of the rulings of this court.
Yes, consider the rulings.
That's a very arguable case for appeal.
And Honorable Single Judge has also categorized in the event it is Honorable Single Judge decided the rights of the parties. That in the event it is applicable, then only.
If that objection within a time stipulation, that I can instruct that consider.
Time will give you, that's all. This informal appeal by the state and its officials seeks to lay a challenge to a learned single judge's order dated
25
of May
20 May 2024, whereby OP's WPC number 12768 of 2024 having been favored, the following direction has been given. Next, sir. Learned AGA appearing for the appellant state vehemently argues that the learned single judge would not have disposed of the matter at the admission stage by giving a direction of the kind to the prejudice of his client. First off, he submits that under the extant rules of this court, once the case is admitted, ordinarily notice will follow and an opportunity of filing the counter would be provided as a matter of right to the OPs in the petition. That is, the appellant's hearing. First off, he submits that this course having not been adopted by the learned single judge, there is error apparent on the face of the record warranting the interference of this court. First off. Next point. He further contends that even otherwise, the appellants have got an arguable case in as much as the services rendered by the employees of office kind cannot be counted for determining the qualifying service for pensionary benefits under Rule 18(3) of Pension Rules 1992
and the amended rules thereunder.
As amended in which year?
2005.
As amended in 2005. Which aspect has not been considered by the learned single judge, and therefore, on that count also, indulgence of the court is eminently warranted.
But that argument has also been made by the State Council in this case.
What is it?
You can't prevent him from saying. As I cannot prevent you from saying.
That is true.
Yes.
That is true.
Next paragraph. Learned senior advocate Mishra, appearing for the OPs, opposes the petition, contending that at no point of time the counsel for the writ appellants had sought for any time to file their pleadings at the hands in the case at the hands of the learned single judge. Not only that, the appellants had participated in the proceedings before the learned single judge without raising a little finger and had fully argued the matter. That being the position, now they cannot turn around and come before this court complaining against the impugned order of the learned single judge. First off. He further submits that the second contention taken up by the learned EGA appearing for the appellant is already treated by in a series of decisions which have attained finality, there being no further challenge thereto, and therefore the said contention does not merit consideration at the hands of this court. First one. In support of this, he has placed at our hands a decision of, is it learned single judge or division bench? You have given without the cost taken. Yes,
Single judge.
It is giving the torso without the head. How to identify?
But the other judgment ballot have been Pradeep Panigre case. I have given that. I have filed that annex that judgment to the writ application. I will the Supreme Court judgment, Supreme Court order also.
So that contention.
But writ application also will say.
So where is that contention taken up? That Panigrahi. Where is that contention taken up? Application of Rule 18.
No, Rule 18, here, my lord, in the present case, para 7, they have said that it is not coming within the purview of the pension scheme. Para 7, they have stated.
They have stated that.
Para 7, page 39. Page 39 of the writ appeal.
Page 40, my lord, relevant page 40. Penultimate para 7.
So they have taken this time. Para 7, the additional government advocate appearing for the state opposite party on the other hand contended that
Panigari judgment it is.
Panigari judgment was also.
You are reading which one?
I am reading up the input judgment ballot where they have taken that down. Input judgment ballot I have also filed along with the writ application.
This has not been discussed.
We are asking. We are asking a question to you again, whether the contention with the learned government advocate has advanced is treated by Another bench of this.
So another bench is that. That part. That part has not been taken.
No, Mr. Mishra.
That part is not there.
Mr. Mishra, in paragraph
Yes,
7.
another judgment it is there, my lord. That judgment is there. That part another judgment is there, my lord. That Panigree case is not there, but another judgment is. Service.
No, in this judgment,
Yes.
In this judgment, it has been
in
written.
para 7 you can see.
Yes, para 7.
Read para 7.
Relevant page is page 40.
Page 40.
No, para 7.
Yes.
Yes, ma'am.
I was just saying. It also contained will not addition government advocate. Person is not a regular government employee, will not be covered under the OCS Pension Rule 1992. It also contains that there is a specific bar in OCS Pension Rule 1992 with regard to coverage of dealer employees, which my Lord Print was showing to your Lordship. With regard to the order passed with this court, Pradeep Kumar Panigree, which was eventually confirmed by the Honorable Supreme Court, the government submitted while disposing the state appeal, the Honorable Supreme Court has finally authorized the question of law is kept open to be decided in appropriate bench case. In such view of the matter, its hand government advocate submitted the question of law, which in larger issue is required to be finally adjudicated, and the same has not been adjudicated by the Honorable Apex Court on the such ground or hand government.
How it is treated? This is his contention.
That is his contention.
Where is the treatment?
No, judgment having had the Lord Counsel for appearing for the respective parties and a careful examination of the contention raised by the Counsel appearing for the respective parties, further on the careful examination of the background facts as well as materials on record, this court observed that initially petition is engaged in DLR basis in 1985. Thereafter, it was brought over to Archer Distribution over the 2011 before petitioner services could not regularize in the regular submission. Therefore, the petitioner, after working content for more than 3 decades, has not been treated as regular employee, and as such, he has not been paid pensionary benefit as is due admissible into such employees. In the opposite context, the court examined the order passed by the division bench court in Pradeep Panigree case on a careful consideration of the said order passed by the division bench of this court. This court found that the factual background of the aforesaid case is almost identical to the facts of the petitioner's case. Moreover, this court in many cases had taken identical view as has been taken by the division bench Pradeep Panigree. It would be also grateful to refer to the judgment State of Orissa versus Dixit Pradan, wherein the order passed by this court directing 1 day regularization before retirement employee and to get pensionary benefit.
No treatment of that contention at all.
No, this
Apex Court in Panigrahi said, we are keeping open this question to be treated in an appropriate case.
No,
which case?
What has happened? Well, in this case, what is that? They have said that whatever the judgment of the honorable court that has been compared with that, for 1 day you will be brought over to regular session, and for that purpose they will be granted pension benefit. That judgment has been delivered by the honorable division bench of this honorable court, and is not only catalogue of cases and confirmed with the Supreme Court. And recently, hundreds of cases also similar cases Supreme Court also dismissed because state government had prepared appeal before the Supreme Court, and hundreds of cases it has been dismissed. Same, exactly on the same point. Exactly on the same point. Exactly on the same point. That is the reason that this the lordship.
So the question was, before the notification came in 2005,
yes,
the petitioner was in the work just establishment.
Yes, yes.
It is only when it has been considered.
No.
That was DLR.
It was a DLR. In those cases, in these cases also, it was not proved.
Then it did not get me.
No.
So, prior to this, the petitioner was a DLR in 1985.
Yes.
And that is how he was considered.
Yes.
That is the case.
Exactly.
Your client gained entry to service when?
In 1985. In 1985.
It's 1995.
My lord, this case, my lord,
for this single bench brought over to the work establishment 18th January 2011.
No, first day.
1995.
85, sir.
That is Bharat.
1985. Yes.
In all aspects, similarly
Similarly, this judgment also, this finality, this also, this contention has been raised.
Just I spoke to the relevant person.
What they have said?
Was appointed prior to the check up from the date of appointment. even appointed prior to 1 by 1 on 2005, they are also entitled for concern. That is in paragraph 24 they have decided.
Because it will be 20 years.
Yes, madam.
As on the date it is amended, it will be 20 years.
Yes. Initial date of appointment is important.
So the period of service rendered by the petitioner as DLR shall be recalled for the purpose of pension.
For the purpose of pension.
That is all.
So for the rule 3 is concerned. So for the entitlement of the petitioner, so far the pension is concerned. That has been strictly barred so far the 3 sub-rule 1 to F is concerned. That is my humble assumption.
But
And
that
kind of a
considered.
My lord,
Yes,
kind of a
report, my lord.
That rule we understand. The consideration may not be to your satisfaction, but there is consideration. It may be arguably a frugal consideration, but it has met its consideration. Because para 8 refers to that only. Though in so many words it does not say, but rules are referred. Your contention is referred.
my contention is there. But
Agreeing with your view, can you create another class of pensioners?
Question is,
or some all of them you will give pension, to this person you will not give?
Here, my lord, so far the 85 appointment, so far the engagement is concerned. In 15/5/1997, one memorandum came. The person those are working for a continuous period of 10 years, their case may be considered according to their seniority, and department will prepare a seniority list according to the divisions. Keeping in view that even from 85, the person those are appointed from 12/4/1993. Here in 2011, he has been brought over to the workers establishment.
Whose mistake it is?
No, there is no scheme. It was a scheme, my lord. So far, this.
We are asking you simple question. Can you bring another class of pensioner? For all of them, you will give pension by virtue of the judgment in Panigrahi. To this man, you don't want to give. Can you classify?
No, we don't want to
cannot classify the pension.
My lord, DS Nakarism, my lord has already discussed in other cases. But fact remains in these cases. These are the barriers so far the 2005, because after that they came into picture. Kind of a glance to rule 3, it will clarify. My humble submission, I am not standing on the way.
3A.
My lord, 3-4, my lord. Next.
3-4.
Subclause 4. Subclause 4. I am just pointing out, my lord. I am assisting the court.
They will not be entitled to pension.
Yes, madam. Then coming to the next page, madam. For a moment. Romaning 3 and last minute. Provided that above provisions shall not apply to the persons who are appointed under the job contract and works establishment prior to 1/1/2005 and brought over to the regular establishment on after 1/1/2005.
What is that? That amendment will not be applicable. Therefore, earlier position will continue in respect of these people.
Yes, madam. But so far this 4 is concerned, and the exception clause is rule 3. Persons in casual and delegated employees, they will not be included in the provision. It was original there.
No, your only contention is not 3A at all.
The DLR and NMR persons,
correct,
as per the pension rules of 92,
casual employees,
they are not entitled to get the pension.
But that contention is rejected in a series of judgments.
That has not been well taken care of.
So, matter went to the apex court. It is not that it is finalized at our hands. It is finalized at the hands of the highest court of the country. Now you want to make an inroad into that?
No,
it's not possible. Because very simple. He is on par with the Panigrahi and the rest of the cases which followed Panigrahi. Matter went to Supreme Court and received the imprimatur. And now it has attained finality. Now you are saying to this person these rules will not be applicable. Means you want to make a subclass within the class. That is not permissible because of DS Nakara. You can't make subclass in the class of the pensioners. That's how DS Nakara's ratio decision is like that one. DS Nakara, Devaki Nandan Mishra.
Devaki Nandan Mishra, yeah.
All they have that.
That has been well discussed in the Malik case is concerned in the other
Yes,
two.
yes.
Nagaraj case also.
Yes, many cases thereafter. Nakara appears to be the standard judgment. Then that has been followed with this in a zigzag way. That's all. That's nothing.
Only that Panigrahi case has been cited, but it has not been
But
discussed.
Panigrahi attained seal at the hands of the apex court.
And after retirement, has filed this petition for appearance.
Because you should have done everything without driving these employees to the court at all. You did not do. Therefore, they are here. Apex court said in a series of decisions in Krishnamurti, where identical facts are covered by a judgment, such a litigant should not be driven to the court at all. Otherwise, pendency goes up. They have to fight the legal battle. They are poor people. And state is a mighty entity. He further submits that in a series of cases pursuant to approval of Pradeep Kumar Panigrahi case, the benefits as are granted to the petitioner herein have been accorded, and therefore accept the countenancing contention of the learned AGA would amount to creating a class within the class of pensioners, which falls foul of DS Nakara, ratio in DS Nakara versus Union of India, right out the next paragraph. Having heard learned counsel for the parties and having perused the appeal papers, we are broadly in agreement with the submission made by learned senior advocate Mishra on behalf of the employee in question, and therefore decline indulgence. First one, the contention of learned AGA that Rule 3 of Orissa pension rules as amended is not applicable to persons in casual and daily rated employment, and therefore they are not entitled to any pension or such other terminal benefits, is difficult to countenance, since such a contention having been taken up has been treated in Pradeep Kumar Panigrahi, which received imprimatur at the hands of apex court in SLP number.
SLP number.
This is my diary number 50364.
Diary number 50364
of 2023.
2023 disposed of on
2/1/2024.
2/1/2024. First one. Next paragraph. The government submission of learned AGA that petitioners, the writ appellants were not given a reasonable opportunity of meeting the petition when the matter was pending at the hands of another single judge is difficult to countenance. First one. Have you stated in your writ appeal memo that we asked for time and the judge did not give?
Only we have given so far this High Court rules is concerned. Chapter 15
There is
rule.
nothing in the appeal papers as to any opportunity of filing the objection, the counter was sought for.
So that in ground B we have said.
Where?
Ground B.
No. You should did you say we asked the judge to give time and he did not give?
But I have contents. Affording any reasonable opportunity to appellant state to file the counter affidavit to rebut the allegation contended in the writ petition. That I have.
The ground taken at
ground number B.
Ground number B is taken up in the appeal is appeal borders evasive pleading. in as much as it specifically does not say that the time was sought for at the hands of the learned single judge and the seeking was negative, unjustifiable.
On the other hand, that made contentions.
And further, all contentions which the petitioner opponents are now urging before this court were taken up before the learned single judge, as has been reflected in paras 7 and 8 of the impugned order. First of all. The vehement submission of Mr. Mishra that in hundreds of cases relief has been accorded and terminal benefits have been extended to employees of the kind, and therefore the denial of the same to his client would tantamount to creating a clause within the class of pensioners, which is not permissible in the light of B.S. Nakara jurisprudence, has abundant force. First, if all similar employees are accorded terminal benefits like pension, etc., denying the same to the OP in this case would be singularly unjust, and therefore that cannot be countenanced.
My same law. My humble submission. Prior to regulation, as he is not coming under the purview, he has taken up so far the Provident Fund pension is concerned, they have opted for the same and they have received the same. Once again, they want to come over to these pension rules, because so far the work charge establishment is concerned, this has been guided by this Political and Service Department resolution of 1974. 74 resolutions clearly speaks about that the work charge establishment, the employees, what they are entitled to. That has been well reflected in the.
But you are taking that contention only as against this employee. Did you take up that contention for rest of the employees?
Other matters, because this is the stand we have taken in this particular case.
No, that again the other contention that the employment under work charge establishment is governed by 1974 resolution of the government, and therefore the terminal benefits by way of provident fund, etc., as are contemplated under the resolution in question.
Not extension, not resolution. It's an instruction.
Instruction.
Not resolution. Resolutions have a different.
It will be instruction to regulate the appointment and conditions of this work charge.
And therefore, more than what has been contemplated under the said executive instruction cannot be extended, is liable to be rejected for the very same reason. First, the state being a model employer in the light of Bhupendranath Hazarika versus state of Assam, has to conduct itself as a model employer and therefore cannot be permitted to take unjust contentions only to gain legal victory in the legal battle. In fact, such a model employer should celebrate when an employee gains victory against the state. First up. Next one. In the above circumstances, this appeal being devoid of merits is liable to be and accordingly rejected. Not having been easy. Within what period you are implementing the order? The order of the learned single judge shall be implemented within a period of 60 days. And compliance report shall be filed with the Registrar General of this court without driving the poor opponent to go for another round of litigation.
What's the break?
8 weeks instead of 68 weeks. We will revert back. So Mr. Fair, we will come back within a couple of like a few minutes.
সেটা more
There, my lord. Here there is a, as per my reading, there is a delay of 7 days. What has happened, my lord? The respondent, who was a manager of the Eco Bank, he was terminated for grave financial irregularities. He challenged this by filing a writ petition before this honorable court, before the honorable single judge. There he took two pleas. The first plea he took was that the appellate authority has acted as the disciplinary authority and passed the order of punishment by which his right of appeal is gone. And the second ground which he took was that certain documents were not given to him during the inquiry proceeding which has prejudiced him. Now the honorable single judge was persuaded by the first ground and he told that he added another person as a party that who is to be the appellate authority as per the schedule given in the discipline regulation rules. Now unfortunately, my lord, the first ground which I would assail before your lordship is, my lord, initially I had appeared before the honorable single judge by filing wakalatnama. But on the day this matter was taken up, my name was misprinted. So I missed the list. So that wakalatnama and that list also I have annexed here. So
take notice.
Yes, there is a delay of 7 days as per my instructions because the order was passed on, yes, 28, 21.
Can we don't delay without notice?
Notice is to go at this stage, my lord. There is a single respondent.
Issue notice. Emergent notice within 4 weeks, both on petition and on IE.
My lord, I have a small prayer. I'm sorry. Item 10 and 11, your lordship told emergent notice. There are at least 13 to 14 opposite parties. If I can maybe permitted 7 days time to take out notice. 10 and 11 both.
10 and 11. It's within
7 days.
Within 1 week.
Obliged, my lord.
Within 4 weeks. Notice.
My lord, obliged.
Item 20. May I please?
Yes.
There's a delay. There's a delay of 4 days in filing of this appeal. And I've filed an IA for condemnation of this delay, my lords. And I've...
What's the merits, Mr. Carr?
The merits, my lord, is that so far as this particular petition is concerned, it is an MSME. It had obtained loan from the banks. Now, as per the scheme of the bank, which was recognized in one of the cases which your lordship was authored that order, but I can't cite it because your lordship said since it's a consensual order, it has no precedence.
And Justice K.R. Mahapatra, I remember.
My lords. Yes. The lordship would take...
no, I remember everything.
So here, my lords, my humble contention is that since it's an MSME, it is covered under a scheme known as the CGT MSC scheme, my lords. Now, as per the scheme, it is floated by the SIDBI, the Small Industries Development Bank of India, which protects the interest of the banks to a certain extent. So in the present case, and the entrepreneurs are women, it is covered till 90%. So what happens, my lord, is if there is, my lord, any default or if there is the loan turns bad, it goes through various stages, SMA 1, 2, 3. And then, my lords, this incipient stress is recognized. So the bank, my lord, has the obligation either to rephase the loan or to give a fresh loan or go in for recovery.
Obligation or discretion?
Discretion. But as per the notifications of as MSMEs are concerned, they have to categorize these loans into the 3 categories. And the scheme itself, the notification for the small scale, micro, small and medium enterprises are concerned. It says, my lord, that please recognize the incipient stress, And if at all you have a problem, try to rephase it or give a fresh loan, or if everything fails, go in for recovery. And to protect the interest of the bank, the CGT-MSE scheme sponsored by SIDBI is there, my lord, which protects the interest of the bank to the extent of 90% in the present case, since they're on the women and entrepreneurs, my lords. But these factors were, my lord, canvassed before the Honorable Single Judge, my lords. And the Honorable Single Judge, in my humble submission, my lords, did not appreciate it, and by Annexure 2 at page 165, the judgment begins at page 169. And if your lordship would see, be kind enough to come to the relevant portion, it's at page 174, my lord, of the brief. Lordship, there's a
reasoning and analysis.
Reasoning and analysis. The first reasoning was that I have a statutory alternative forum, and they say one. Yes. What has happened?
Yeah.
DRT you have. Yeah, true, my lords. But ProNet's case says that this has to be done prior to the recovery proceeding. Once the bank ignores this and goes for a recovery, and the entire process of the recovery is begun and over, I can't go for the scheme. That is ProNet's judgment. I have an ex-ProNet's judgment.
You can't go to DRT at all.
No.
That contention before the DRT.
No. The DRT, my lord, once that proceeding begins, this scheme, under the scheme of this CGT-MSME scheme, is out for me. That is the ProNet judgment of the Honorable Supreme Court. So all those actions have to be done prior, because recovery is the last resort as per the CGT-MSME scheme, and the notification so far as MSME is concerned. Because before they come to the recovery part, they have to try for refacement, they have to try for other restructuring of loans, my lord, before they come to the recovery. So once they go to the recovery part of it, they can't come for the earlier two, which was there under the scheme, under the notification.
But learned single judge has mentioned Satyavati Tandon judgment.
That is, my lord, Satyavati Tandon says that I can't come, so far as banking matters are concerned, I can't come directly to the High Court. But unfortunately, my lord, the Honorable, in my humble submission, the Honorable Single Judge missed out that particular line of ProNet. The first ground, my lord, is alternative remedy. This and the Satyavati Tandon has been discussed. And if your lordship would kindly come to paragraph 8 at 176. Last 3 lines of that paragraph. However, the present case does not disclose any such extraordinary circumstances that cannot be adequately addressed in the statutory forum. Now, this, in my humble submission, is an incorrect, I may say, pardon me for saying so, in view of ProNet's observation laws. Then the Honorable Single Judge says at paragraph 9, here the petitioner's allegation of arbitrariness and non-compliance with RBI guidelines can be raised before the DRT, which is empowered to examine whether the bank's sanction were in accordance with law. Mere assertion of a guideline violation or principles of natural justice without more is not sufficient reason to bypass the statutory remedy. Then the Honorable Single Judge says that the writ petition is not maintainable on facts.
What ProNet said?
Yes, ProNet, my lord, your lordship would say I have annexed ProNet for lordship's kind consideration. ProNet's 312, it begins. Annexure 15 and
to take this play at the very first
stage.
Yes.
And my lords, my NPA was declared in 2015. 25. Yes. Since January. Since 2024, and the Honorable Single Judge notices that I have, my lord, been writing to the bank that these are the conditions for which I cannot, my lord, operate my business. Please help me out because before my loan turns NPA. And if your lordship would appreciate, that's why, my lord, if your lordship would again come back, my lord, to the Honorable Single Judge's order, the Honorable Single Judge has noticed that fact. If your lordship would kindly turn
Mr. Kora, before the NPA, you have not been categorized as a...
No action has been taken. If your lordship would appreciate...
But you knew that you were under the MSME?
Here, my lord, the scheme, the bank, my lord, unless I am an MSME, had brought into the CGTME scheme, I'll show the sanction letter also that here no collaterals were given.
So that's all right. But you are knowing that you are under the MSME?
I know that I am under MSME.
And when the bank finally came for NPA, whether you have raised this?
No, right. Exactly. Your Lordship will kindly come to page 178, paragraph 13. The Honorable Single Judge has observed that. If your Lordship come to paragraph 13, in other words, Lordship got it,
In other words,
the statutory MSME revival framework cannot be ignored by a bank at its will. It is intended as a pre-NPA corrective mandate to protect the viable MSME unit. The petitioner's grievance is that the SBI failed to follow this framework. The undisputed fact shows that the petitioner's loan account turned irregular, your Lordship may kindly mark it, in May 2024 due to a severe disruption, a 4-month power supply outrage in its dairy plant. The petitioner, your Lordship may kindly see.
Issue notice. Issue.
And your Lordship may kindly protect it because now the DRT is about to proceed and the date is fixed to tomorrow.
So what is the stage? 13-2 has already been issued?
No, it has not been disposed. They have just begun. Yes. Because the paper publication, they filed an application for paper publication and the date has been fixed to tomorrow.
Heard learned senior advocate Mr. Carr appearing for the petitioner MSC. The case is made out for issuance of emergent notice and grants of interim protection pending deleted. Personally. Next one. In the above circumstances, issue emergent notice, returnable in 3 weeks. First one, in addition to taking usual steps, it is ordered to the appellant to serve copies of petition on the panel counsel appearing for the bank and other standing counsel, if any, appearing for any of the OPs. There shall be no precipitatory action against the appellant till next date of hearing.
Lordship, mark the OA number, so that the OA number.
There shall be no precipitatory action in OA number.
Let's
144 of 2025 till the next date of hearing. Well, copy to the extent of that. Yes.
Urgent copy. Urgent copy subject to your Lordship. Yes, much obliged, boss.
Item 21.
21, same as item what is implemented. Pension, same as item 18.
Is it true? Same matter.
Almost all identical.
The subject matter of this appeal,
But I will reiterate the same thing because of the
is substantially similar to the one in writ appeal. Serial number? 18.
Serial number 18.
18. No. 18.
that was 18.
Which has been heard and decided, dismissed today. Similar cases need to be treated similarly. Is the ground norm of adjudication as rightly contended by the net counsel appearing for the OP. First, next up, in the above circumstances, this appeal also meets the same fate as the complaint appeal met and accordingly dismissed. Next.
Item 22.
Yes, sir.
Let's see, item number 22, it is a case relating to rehabilitation scheme and the applicant challenged in this case annex 10 of the rejection rejected by the Honorable Tribunal and rejection under government rejection under annex 8. That's that in this case the applicant while
applied the rehabilitation scheme, the post was approved by the department under Annex 5 in 2010, Lordship. Applicant father was died in 1999.
1999.
Yes.
What was he?
He was a Mazdoor in work charge employee. And he was appointed during year 69 and expired on 99.
Khalas. Died on 1999. Give the date.
Date, Lordship, death certificate is Annex 3, 2012, 1999. Annex 4 is the legal heir certificate. Only daughter was applied for the post and mother is consent to the petitioner. Government has approved the post. Annex 5.
After one sentence, there should be full stop. At least comma.
Yes.
2012-1999 is a death in Hornet. He has got one widow, one daughter.
Only the widow and daughter.
And the daughter staked a claim for a compassionate appointment. That application is dated?
In due date, Lordship.
No, what is that?
I am not annexed, but government already approved the Annex 5.
All right. Why tribunal did you are telling what order?
What Annex 10, Lordship. The applicant earlier approached the tribunal for giving appointment. The Honorable Tribunal directed to consider the case. They are rejected. In meantime, the petition was married.
On the ground that she is married. What is the property holding of her husband?
Husband is.
Suppose if husband is after.
No, that is unemployed.
We do not know. Where have you stated? I can't assume all that. You can't say out of the hand like you are even saying Katak market.
Yes.
You are in the courthouse.
Yes, and therefore, Lordships.
Where have you stated?
I am not annexed, Lordship.
But we say he is IAS officer. You say he is a laborer. How to decide?
Highly affidavit is not
what
working.
Is his property status? How many acres of land? How many buildings in Cuttack, Bhubaneswar, etc.?
No, it's a backward state.
Whatever, sir. You have to plead that you are not in a vegetable market. We are in a court of law.
And similar situation, similar matter already decided by one High Court in judgment. Lordship can pay.
What is the position, Mr. G?
My lord.
Can a married daughter be denied compassionate appointment on the ground that she is married?
My lord, that is the rule. The rule says, my lord.
How rule is interpreted by the courts of this court?
Here our own High Court of three judgments.
Rehabilitation, Odisha Civil Service Rehabilitation Assistance Rule 90. Rule 2. 2B, my lord. Lordship may kindly have a look. Family members shall mean and include the following members in order of preference.
Excludes married daughter?
Yes, unmarried daughters, unmarried stepdaughters.
Unmarried daughter, it excludes. It includes.
Unmarried daughters, it includes.
No, but there is one judgment which your brother is citing.
Yes, no.
Kindly look into that.
Yes, as the Basant Naik case, Lordship, Basant Bera case, Lordship, and paragraph 16, Lordship, the Supreme Court decided it.
There is one section in the Indian Succession Act.
Page 11, Lordship.
Which says, marriage per se will not disentitle a person to the benefits, otherwise benefit. There is such a section. Unless there is. No. The applicant section. No. Preparation marriage
The applicant already applied at the time of unmarried. After 7 years.
Yes, you are not answering either on law or on facts.
Oh no, it's wrong.
Which is that section in the Indian section? We are giving the statute book now.
Judgment reflected in the judgment.
We are holding a book to you.
Yes.
Just turn the pages and tell the section which says, on account of marriage, no disability. Because that section is not stated by the other judges of this court. Can anybody tell which section in Indian Succession Act? Mr. G, you take notice and
notice was issued. We have filed counter.
Then what is your contention?
My lord, contention is.
Have you
that-
seen that judgment?
No, I had not seen that.
Just look into this judgment.
I'm looking at your lordship may call this matter next week so that he will, my lord, this, I am to get a judgment that if the family is in distress for a quite long period, can manage to survive, no rehabilitation can be given. Here, my lord,
is it on what ground it is rejected?
It is rejected on the solely on the ground that
He is married.
it is married.
Then where is the
Married
distress
daughter-
point you are arguing?
My lord, married daughter cannot claim rehabilitation.
No, that is rejected by the other judges of this court.
That is my alternative argument, my lord.
Because Supreme Court said matter arose from Karnataka. The apex court said on the ground that the daughter is married, you cannot deny compassionate appointment.
No, our rule says that.
Similar rule was there in Karnataka. That has been struck down by the learned single judge, Justice Nagprasanna. Matter went to the Supreme Court. Supreme Court affirmed the judgment. Otherwise, marriage will be a disability, which will be contrary to the provision, which he is not able to show to us. I go through the judgment. There is such a provision in the Indian Succession Act. Marriage person, 28 Act. Give that.
The person's marital status or physical mental condition does not affect their fundamental right to inherit property under his succession.
It is not that. It's not.
But American court, Justice Neely of American Supreme Court, American court, not Supreme Court, some court of Justice Neely said, right to appointment partakes the character of proprietary right. Our courts have not gone to that extent.
Yes.
That is 28. Not of that is what I know. 20. 20. Interest and powers not acquired nor lost by marriage.
Yes.
This section. No person shall by marriage acquire any interest in the property of the person whom he or she marries, or become incapable of doing any act in respect of his or her own property, which he or she could have done if unmarried.
Yes.
They have said like this.
My lord, that is so far as daughter part is concerned. But at the time of death, my lord, wife was survived. She was survived with a wife.
No, survival is not the point. Everybody will survive by big balance.
The wife was there. She could have made an application for getting appointment.
Widow.
Yes, widow.
The rules provide for, no, she gave consent.
Rule is clear.
No, she gave consent for the appointment of.
No, consent. That part is not. It is silent about consent.
No, it is decided by courts.
No.
Where there is a widow.
I am to go by the marks, my lord. Rule says.
Just look into that.
Next one is the affidavit filed by the mother, lordship.
After marriage, if she will go to maintain her in-laws family, what about the widow?
But even that aspect is considered. This argument is also considered.
What about this widow?
One matter we held in Karnataka, myself and Justice Varale Saab, where she goes to the in-laws house, as a matrimonial house, and she is very rich there. She cannot seek compassionate appointment. We have held that way. Can you get that judgment? After referring to Justice Nagprasanna's judgment, in the bench comprising of myself and Honorable Justice Varale Saab, now in Supreme Court, we held once marriage takes place, she goes to the matrimonial home, and there are as many as 13 legislations which give her protection. Therefore, she cannot seek compassionate appointment. We took up that view. In one matter, I don't remember. Maybe October, November 23. 20. You are right. Priyanka. Priyanka versus State of Karnataka. Is it reported?
2024 AHC 12880. Just look into if into Apex code also. Just look into it. Just look into that. Yes. Next week. At the request of the DG, Mr. G. Okay. So that
Item 23.
Excuse me.
Yeah.
My lord, in this matter, my lord, the petitioner has challenged the forfeiture of security deposit, my lord, of the auction amount. 25% of the auction amount, my lord.
25%.
Yes, my lord.
On what ground?
My lord, on the ground of that default payment.
He did not pay the rest of the amount.
Yes, my lord, in between there is a glitch, my lord. What happened? That property which has been auctioned, my lord, without showing any encumbrance on that was auctioned. And in the meantime, there was a suit to that property, and that has already been decreed in favor of the plaintiff in the meantime. And this is not a simple default as per section 9(5) of security interest rules, my lord. My lord, there is a judgment given to that effect. And this is my only submission.
You did not pay because there was a suit decreed.
Yes, my lord.
Is it a title suit?
Yes, my lord. I have already annexed it in my additional affidavit, my lord.
Lord, bank has advertised for auction sale of the property on 30th September 2011. 11. Then auction sale conducted on 16/11/2011. And the terms and condition of the auction sale, my lord, your lordship, and it has been categorically stated that as is where is basis it will be sold, and the petitioner.
But you did not disclose the pendency.
So I am coming to that. What happened? Actually, bank was not party to the suit. This is a private suit, and mortgage was created prior to the suit. So bank is not aware about any suit is pending. I am coming from background. Gradually, your lordship will understand what is exactly the mechanism and how she has been now acted as henchman.
OS number?
Miller?
OS number what?
OS. Miller.
Which is that OS? Suit.
Suit civil suit number 27 of 2007. 2007.
27.
Yes.
27 of 2007, Miller.
One
But
second.
in that.
1 second.
Yes, my
This was between whom?
my lord.
Between whom?
Between one Ram Avatar Modi and my lord.
The development.
Once a minute. Who posed a question to me? Let me answer. And 29 respondents were there.
Decreed on?
Decreed on, my lord, on 28 2016.
Decree is what?
Judgment for declaring the sale deed as invalid. Sale deed of 6/21/22/24 of such and such persons whose property is auctioned, that is respondent number 24, that has been hereby cancelled. Intimate the sub-register Ghatak accordingly. The defendant number 1 and defendant 6/21/22/24 are hereby restrained from further alienating or encumbering any portion of the multi-storied building in favor of any other third party, and are to hand over the vacant possession of those flats to the plaintiff within next 3 months. And by this time,
Only one sentence. Full stop. Allow the judge to process whether you are lying
my
or you are
apologies.
seeking proof
My
or
apologies.
unintellectual.
My apologies.
This mortgage is a registered mortgage.
No, it is equitable mortgage.
Equitable mortgage.
Equitable mortgage. So,
But equitable mortgage does not require registration at all.
no, here
Only depositing the title deed.
Title deed and only the confirmation from the party who was creating the mortgage. So that is why it is in the state, there is no.
The sale deed which you were holding by way of equitable mortgage, that sale deed is declared to be invalid by the suit.
Yes.
In the suit.
That power, the right, by virtue of one power of attorney, my lord.
No matter what is
That
the sale
was-
date which you mortgage, the equitable.
Sale deed is of which year?
My lord, I am the
2004.
option purchaser, my lord.
2004.
2000 full date you have to give. There is no
Yes.
culture of giving the date in your court. Give the date.
Milord, I'm just. That is first day of December 2004.
1/12/2004
Milord.
is the sale deed.
Sale deed.
When the mortgage took place?
Mortgage took place, Milord, in that 8/4/2001 minutes.
Huh?
Mortgage is created
It
in
itself is 1/12/2004.
Milord, the 1st December, and thereafter 8 December, their mortgage has been created in favor of the bank.
8/12/2004.
Milord.
Huh? No, how could it be?
The 1st December it was executed, Milord, sale deed. Thereafter mortgage in 2004, December 8/12/2024.
8/12/2004 is the mortgage.
Mortgage.
Suit is subsequent.
Subsequent 2007.
And you are not a party to the suit.
Milord.
But how they will, suppose if there is a suit, title suit,
Milord.
still you expect the auction buyer to pay rest of the installment amount.
Milord, just a minute. When the bank has advertised and said that you go and do your due diligence, and thereafter she has participated. What happened, Milord? The person, this present person is a tenant in the same flat, and the guise of the borrower, he has come forward to say thereafter that this property suit has been filed and it's been nullified, only to check the bank. That bank should not go for enforcing its right. So, Milord, first of all, my submission is it is not maintainable before this honorable court because there is Supreme Court judgment, Agrawal Tackers, that this should be decided by when there is a factual dispute or any dispute relating to enforcement or exercise of power under SURFACE Act by the DRT is the competent. Second,
Go by one by.
Milord, first. Second, first, my maintainability I am raising, Milord. It is not maintainable before this honorable court because
for future also.
For future also. That is the judgment. I am just showing you, Lordship. Agrawal Tacker, you will not see. I will see the paragraph.
They should go to the DRT.
DRT.
But after 14 years now.
No. At that time when the matter was there, so it has come in 2000, your Lords. I am coming to the paragraph.
The petition is pending since how long? 2012.
12, Milord. This judgment has been passed, Milord, in paragraph 33, your Lordship, see.
2018 judgment.
Judgment. We are of the considered opinion that the appellate court were justified in dismissing the appellant's writ petition on the ground of availability of alternative statutory remedy of filing application under section 17(1) of the SURFACE Act before tribunal concerned to challenge the action of the PNB forfeiting the appellant's proposal.
And what do you say about this?
Yes, my lord.
We will condone the period that during the pendency of the prosecution of the petition under 14 of the Limitation Act, and you go before the DRT now. They will be able to decide because they have expertise in the matter.
My lord, my humble submission before your lordship is that after they forfeiting my amount, I have intimated them categorically. There is one judgment of Utkal Highways, my lord.
No, your apex court judgment.
My lord, mine is also apex court judgment, my lord. Utkal Highways, my lord, where it was clearly depicted when there is an exchange of pleadings, which counter has been filed in the year 2025. In this case, when there is already an exchange of pleadings between the parties and no factual dispute involved in the question, then alternative remedy cannot be placed into service. And my lord, I am handing over another judgment of Honorable Supreme Court, where it is clearly stated that alternative remedy is not a bar, and with interest, the forfeiture amount has been refunded.
Government of India.
Oh.
Have you seen that judgment? I have seen one of the judgment where that is from different angle. It has been said that the person who has participated in the auction, Millard, the order of the DRT has not been communicated. That is, but I will just provide this constitutional bench judgment where it has been clearly stated.
My lord,
I am showing constitutional judgment, bench judgment of 2024 by Justice Dhananjay Chandra.
Mention the names of people.
Miller. Judgment is authorized officer, Central Bank of India versus Sanu Magavelu. It is the constitutional bench.
What is the proposition?
ET proposition is four proposition is there. If the amount will be forfeited, whether bank will be enriched or that is first question. Second question, whether section 73, 74 of the Contract Act, whether it is violated. They have answered. And they have answered also the overall tracker. And again, they have said, if this amount will be forfeited, it will not go to the payment of the use of the person. They say this is because of the special statute, it will override the Indian Contract Act. So, by virtue of the special act, so they have decided that this SURFACE Act will be prevailed and the party should go to there for redressal of the grievance. And second thing they have said, if suppose for the sake of argument, if the bank will pay the amount, then again bank will go for advertisement. Whatever the cost bank will incur, whether bank will go for filing a suit against the person those against whom they have refunded the money, it will be preposterous, they have said. So all these arguments have been met. Your Lordship come to, I am just para 60. I have 61 Millard. Para 61 Millard. I have come all these paras very categorically stated. Legislature through rule known, your Lordship got in this constitutional bench judgment, para 61 Millard.
They say your right to recover whatever you have deposited arises under section 73 and 74 of the Contract Act. They agree with this proposition. Here's what Apex Court has said. Whether we agree or not. Number one. Secondly, the Apex Court says the forfeiture is not act of the bank, but it is operation of law.
Exactly.
Yes, fine.
Second one. If forfeiture takes by operation of law, your argument of equity that I should not be put to loss because there was a suit is decreed, so that will not give me the title to the property which I have bought in auction. So it falls to the ground. It may be hard. It may be a little hard, but that is the law.
But I handed over this 2023 Mohammed Sariq, my lord.
No. This is a full bench judgment.
Yes, my lord. Yes, my lord. I bow down. Bow down. Here the only question is, my lord, whether the alternative remedy.
Not alternative remedy. Your right itself.
Right itself, my
No
lord.
right to recover.
Right to recover. My lord, this forfeiture is rightly
Because it is the operation of.
Yes, my lord. My lord, my submission before your lordship, my lord, is that this is not a simple default. This is not a simple default. And on the Transfer of Property Act also says, my lord.
No, that act is not applicable because Transfer of Property Act, the pre-council say, is an extension of the Contract Act.
Yes, my lord. My lord, as per the security interest rules, my lord, which I am showing, it is there that they have to clearly mention the encumbrances over the property, and this property has been subject to suit in the year 2007, and I have clearly intimated them stating that there is a suit pending and my forfeiture may not be carried out, my lord. I have intimated.
Which is the encumbrance to be stated? Which is
yes, my lord. This is security interest rules, my lord.
Which rule?
Rule 8.7 of F.
Please read.
Yes, my lord. Every notice of sale shall be affixed on the conspicuous part of the immovable property, and the authorized officer shall upload the detailed terms and conditions of the sale on the website of the secured creditor, which shall include the description of the immovable property to be sold, including the details of the encumbrances known to the secured creditor.
Known to the security. Yes. Does not know that.
My lord, thereafter I intimate that.
Known to the security. Known to the security.
Secured creditor, my lord.
Not knowable.
Yes.
To the security, the lenders.
Yes, my lord.
Because known or knowable is used in section 17 of the Limitation Act. If he could have known.
Yes, my lord.
So Parliament uses the word known to the security holder. He does not know about the suit. You only inform subsequently.
My lord, I also, because my lord, without
that's an equity argument.
my lord.
It's an argument of equity.
Yes, my lord.
So without place, equity argument has no place in SARFAESI proceedings.
Yes, my lord. My lord, I can I submit, my lord, fair submission? Can I take one date so that I can go through those that?
You come afternoon.
My lord, not.
Call next week. The request of the counsel appearing for the petitioner. It appears to be this also I did not know. We were selling with you because I was selling with you at least because I thought why you should be put to injustice. Thank you for enriching the court. That is me.
Because paragraph 111 of the said judgment has.
No, I was under impression that she would be put to unjust poverty. She would be impoverished to the amount you forfeit. And to that extent, you will enjoy the unjust enrichment. That is not like
that is not there.
Thank you for coming with so much research. Thank you so much. Yes, pass over, man. Yes,
Item 2, pass over also falls with lordship's same ratio. But from my humble submission, lordship, here the SARFAESI Act is not meant for augment of state revenue or lordship revenue generating.
That argument is considered 2024. This argument is also.
But in this case, lordship, they have put to the property without my knowledge in higher rent.
Please, let me, sir. On last occasion, my lord says passed an order on deposit of rupees 20,000. The counter affidavit will be accepted. So accordingly, I have deposited that amount that my counter affidavit may kindly be accepted And I have also.
Not deposit, the word deposit cannot be correct. Payment to
Already
welfare fund.
your original receipt
We
is
will repair that order, brother judges.
already.
You have paid that money.
You have paid that 20,000
By the
rupees.
order dated 15/12/2025, the OP bank, your bank,
My lord.
OP bank was put to the rider to pay a sum of, to deposit a sum of ₹20,000 in the High Court Advocates Welfare Fund. First off, learned counsel for the banks, panel counsel for the bank submits that this amount is already deposited. First off, it hardly needs to be stated that the intent of this order is that the bank should pay as contradistinguished from mere depositing the said amount. First off, accordingly, the amount deposited by the bank shall be treated as having been paid irrecoverably to the High Court Advocates Welfare Fund.
My lord.
When do you want?
My lord, this matter may kindly be taken up next week, and I will come up with so many judgments. So for the forfeiture is concerned.
My friend will borrow all the judgments.
You borrow judgments. You have borrowed money. Borrow judgments also. God bless. Yes.
One capital lordship.
Next.
No, one capital lordship.
Lordship.
Grateful.
Yes.
Item 24.
Your Lordship, item 16 was passed over, Your Lordship. I have already informed the other council, Your Lordship, if it may be taken up any other day, Your Lordship.
16.
16.
That's very good, sir. Yeah.
Pleasure, Your Lordship.
When it's item 24, I'm finding the consolidated cost title, Your Lordships. There's a noting that consolidated cost title has not been filed.
You have to file it in the registry. Filing is always in the registry.
I'll file it.
Registry is meant for filing.
Yes, Your Lordship.
We for adjudging.
Yes, sir.
Yes. Call next week. In the meanwhile, order dated 22/8/2025, it to be complied with. Yes.
Obliged.
Item 25.
In the case, the Union of India is challenging the order of the Land Central Tribunal. It is Annexure 3, page 64. Crux of the issue is that an employee under the Postal Gram Sevak scheme, he was appointed, and her age was less than 18
when appointed.
So in this process of selection, the specific advertisement CBSE page.
But you are ready in the matter? Yes. Ready. Will come in the afternoon?
Yes.
After eating our lunch?
Item 7.
Your Lordship, in this case, Union of India is challenging the order of the Hon'Ble CAT.
Yes.
With regard to financial upgradation, Your Lordship. In this matter, Railway Advocate, the Joint Court below, they have stated in paragraph annexure 1, last paragraph case 31. As a consequence, it was held that the applicants were rightly allowed the first and second financial upgradation on the recommendation of the screening committee by order number annexure A1, which is ought not to have altered without giving opportunity of being heard to the applicant in compliance with the principle of natural justice.
Correct.
However, in course of hearing, it has been brought to the notice of this bench that the respondent have filed special leave application number 11521 of 2018, challenging the order of the CAT, New Delhi, which is upheld by the Honorable High Court of New Delhi and the Honorable Apex Court by order dated 8/10/2018, stayed the proceeding of the contempt filed by the applicants therein before the CAT PB, New Delhi, and directed to list the matter in the first week of 2018 for final disposal of the matter seems to pending before the Honorable Apex Court for final adjudication. Since the matter is pending for final adjudication before the Honorable Apex Court, the restoration of granted by the applicant under Annexure 1 series subject to final outcome of the special leave application. Your Lordship, in this matter, rightly we have come to know that the SLP has been dismissed. Held by the yes.
The order of the High Court is affirmed.
Order of the CAT has been affirmed.
CAT went to
yes, Your Lordship.
A CAT order came to be affirmed by the High Court.
Yes.
Then matter was carried to the Apex Court.
Similar matter carried to this Apex Court, and there has been.
Yeah. Then what remains in your case?
Since similar matter is pending before Your Lordship, 28932 of 2025, Your Lordship posted the matter on previously on 31st 10 2025. All the matter to be tied together, disposed of.
We will make order in this. This order we will print in rest of the matters. You give the list, we will list it here. No, this is the list of the matters, all right. But this order, we can make order now. There is nothing remains there.
Nothing remains. But I pray that matter may be tagged together along with
that prayer we have stated now. We will print this. I have
to get instruction from the railway whether review application is filed after dismissal of the application in the Apex Court. That instruction I want.
No, that after that, if review petition is dismissed, you will ask your counsel whether curative petition is filed.
No,
that does not take anyone anywhere. As the order now stand.
Only I have to get instruction, Your Lordship, 15 days time, then Your Lordship will dispose.
No. Counsel for the CGC appearing.
Central Government Council.
Central Government Council.
Senior Panel Council, Your Lordship.
Senior Panel Council appearing for the petitioner. Sought for time to ascertain whether the decision of the Apex Court is put in review. First off, that fact, on that ground, no adjournment can be granted because once the highest court of the country takes up a particular view, the presumption is that no review is filed unless the filing of review is demonstrated. Next paragraph. The matter does not require any further adjudication in as much as the CAT order in OA number
260.
No,
260 of 2000. 263 of 2021.
The OA which that is Delhi.
No. This one.
OA number 260.
Annexure 1.
Bar 00263 of 2021 was allowed in favor of the employees employees concerned. First off, the same was put in challenge in WP number.
No, Lordship, that I don't know. This is the WPC number we have challenged.
No, not WPC. SLP.
SLP number that is there.
You went to SLP directly.
The similar matter, Delhi High Court passed an order, and against that order.
That matter was before.
Yes, before.
First off, Council submits that similar matter was decided by the CAT Delhi, which eventually traveled to Delhi High Court in which case it is? Delhi High Court case, WP number.
That is not there in the Lordship.
No, that is there. WPC 10995 of 2016. 10995.
995 of 2016 disposed of on. Just disposed of and so. First off, the said matter was carried in challenge before the Apex Court in is it SLP?
In SLP.
In SLP number
11520 and 11521 of 2018.
2018. And the same came to be negative. Why the order dated?
18/1/24. Yes, sir. 18/1/24.
18/1/2024.
What do we see from your application only?
Yes, sir. 520, 1152.
I will inquire from the
1818. This code of void order dated 18/1/2024. Negative. First of all. Since the order of Delhi CAT as affirmed by the Delhi High Court, having got imprimatur at the hands of the top court of the country in the subject LPs, the order of the CAT Cuttack now impugned before us does not merit deeper examination. First one. Next one. In the above circumstances, petition is dismissed. Registry to send a copy of this petition to the OPs. How many OPs? There are by speed post for their information and this one. When now anything to be done from your side? Any direction is given to you to do by the CAT?
No, Your Lordship, there is no direction.
No direction. It only
except it was pending before the Honorable Apex Court. That is why it was disposed of.
All right. Yes.
Item 25.
Bracket. Mention the tendency of the CAT when CAT got bracket pass of this bracket complete. All. Which call WPC. See, these two matters you have to get posted. 28623 of 25, 28641 of 25. Okay? Post it tomorrow. Yes.
Item 25.
Yes.
This is a case and he is challenged the order of the Lord Central State Tribunal.
Yeah.
Passed on 3/1/2019.
Yes.
It is annexure 3, page 64. The crux of the issue is there. The person is given appointment, even though she is below of 18 years of age, 3 months is not there, 17 months, 17 years, 9 months. 9 months. She was convicted.
What was her date of birth?
Date of
birth.
His date of birth is
7th June 96. 7th June 96, madam.
7/6/96.
Yes, madam.
Date of appointment?
Date of birth 9th May 2014. 9th May 2014, madam. He got the appointment. And the selection process is prior to that.
Yes. That is 9 months, 9 years,
17 years,
17 years, 9 months.
Yes.
11 months.
Lordship may see the annexure, page 22. Annexure to the advertisement, that is annexure A/3.
He should be major. He or she should be major.
18 years. Just submitting to there, Lordship may see the GDS rules.
No, what happened in the CAT?
In CAT, CAT allowed the order that directed us to give appointment. I am just coming to the relevant paragraph. My last two paragraphs I am just reading.
You had not given appointment even despite selection.
Yes. What happened, we have found after giving joining to her, we found that particular officer has managed this and given appointment. She has
joined.
That's why we have taken action. She didn't allow to join. She didn't allow to continue in that post, GDUPM, as well as
how many
office. That is his
2.5 years from appointment.
2014 to 2000.
About 2 years. 2 years after appointment.
2016.
2 years after appointment.
Yes, sir.
She was discontinued.
For how many? Terminated. His service was
terminated.
Continue without following that procedure. That was the
One after another.
Continued till
She continued till
18/4/2016. Termination order was issued
on
18/4/2016.
how you came to know that she
Then
was
complaint from some
Others.
source. Then we examined, found that the particular officer is. Yes.
in the application for appointment?
Yes.
That was pursuant to particular advertisement.
Yes.
What is the date of advertisement?
That is the date. That was I am showing by the page 22. That is dated 14/8/2013.
14/8/2013. 2013. Any clause is there? One, those who are minors who become major particular cut-off date, they can also make application.
That is clause 4.
What is that? It is there.
I'm just reading, man.
Yes.
The applicant must be more than 18 years of age and below 65 years of age. This is a specific noting in the advertisement itself. And the applicant should not be an agent. Other things are there. And another clause 3 says the applicant must have passed the matriculation or equivalent examination. According to the matriculation certificate, it is found that 17 years, 9 months. And the Lawrence Tribunal says that particular paragraph, I am just reading paragraph 14, page 74, Lasimesi. It is submitted in the way para 5.5 that under the rule, there is no minimum age prescribed for the appointment of the GDS in the GDS Conduct and Engagement Rules 2011, which has not been contradicted by the respondents.
Do you contradict here now?
Yes, we have filed the counter, my lord. In counter, we specifically stated so.
Which rule?
That is Rule 8, subclause 1.
So that.
I'm just.
Rule 8, subclause 1.
Yes. Of GDS rules. Termination of engagement.
No.
Come to GDS.
Rule prescribing
Minimum age.
Minimum age for appointment.
Yes.
Terms of the condition of the engagement clause. That is rule 3.
Either he should continue or I will continue.
I'm just passing the book.
Either
I'm not submitting anything.
You're not required to submitting anything. If you require, then you can submit. No issue. That is on method of recruitment. Yes.
Mr. GST, is there any rule?
Yes, I'm just showing this.
Which says he should be a major?
Yes.
Which is
that I'm telling a method of recruitment, that is the GDS rules, revised eligible for engagement of GDS posts. The age is criteria. I'm just passing on the books after reading matter. The minimum and maximum of the age for the purpose of engagement to GDS posts shall be 18 years and 30 years respectively, as on the date of notification of the vacancy. The maximum age shall be relaxable on 3 years to those belonging to the OBC, 5 years, and the SC. This is the rules. I am just passing.
Get here, Xerox copy of that first page and that rule. You back that. All right.
GDS, I am just clarifying one thing. GDS is posting of the postal department are not the civil post. They are governed. No, they are governed under the specific statute rules.
They are like extra EDA, extra departmental.
Yes.
They are not.
They are not civil at all. They are not coming. But their conduct, their inquiry, everything covered under these rules, and basing on that, we have been acted up. These rules provide that
they don't hold civil post.
They don't civil post. That's why, my lord, their inquiring authority is the inspector of this postmaster. Others, those who are employed in the postal department, the superintendent in the.
When you made appointment, selection and appointment.
Yes. Let's see.
No, I'm asking you a question. Question is not over.
Yes.
sentence will be over after a question mark and full stop.
Yes.
When you conducted selection, whatever legal selection it may be, and issued the appointment order, had she suppressed anything?
Yes.
What she had suppressed?
She is suppressed in the time of fulfilling the application. She has written her date of birth, such and such.
Yes. Where is
The official, those have verified the same, he has tempered the same and allow her to join.
What she should do?
But he is connivance with. That's why we have taken action against the officials. We have taken proceeding against the officials. He is discharged from the service. And also we have taken action against them.
Where is the complicity of this girl?
Because he knew herself that I am below 18 years. She herself knew very well.
No, she told also. She had given the SLC certificate to you.
Yes. That was shows that his age is not fetching 18 years.
Correct.
In spite of this, he submitted application.
Yeah, I file an application.
Yes.
It is for you to verify.
Yes, that's
I
true.
give everything.
That's why you have taken action against the officials. Those have connivance with the guard.
Who is the conniver?
That our officials.
Your office. You had been to the nearest tree nearby post office.
We have taken action against this.
Yes. Why action against her?
And the person, those who have not faced the age of 18, how can she be selected as a post officer?
You selected. How can you select it?
But the rules provide that we can also take action in this regard. That's why I am quoting Rule 8 subclause 1 of the GDS rules. These rules provide with notice and properly we have taken action in this regard.
After 2.5 years, you are going to take action after retirement. Can you say that?
My lord, we have definitely this system will believe its own officials. Suppose any officials committed a mistake and any allegation is coming from any of the side, but other general allegation or any other official coming, we have inquiry into all. Without inquiry into, we cannot go immediately. So after inquiry found that she has below 18 years, the officials those have involved with this issue.
Who is that official? What is the rank of that official?
That is his inspector.
Which is that? What's the rank of that official? What is his qualification? What is his stature in the department?
That I have to share all the details. Because we have, according to my instruction,
yes,
we have taken action against the official those have committed all sort of.
With that, you should be happy. Why against her?
Not like this, my lord. If once I'll give you all details to this, who is the officer, what rank he has, what action have taken.
We don't
think because it is different subject matter. That's why.
No, we don't take it. What's the reasoning of the tribunal? What tribunal says?
Tribunal only says this. I'm just reading my. Page 74, Lordships. Last paragraph.
75.
Yes. Internal page 12 of the assessment. Yes. For the reasons as discussed above.
No, what is the reason I'm asking?
This reason is there in page 13. Page 74.
It cannot be 13 because of
it is serial 13, page 74, internal page 11. Then Lakshmi is a big paragraph. We have to continue from paragraph 12. That is start from page 70. It is page 70, paragraph 12.
No, why the CAT says there is no such rule? Maybe that this much argument was not done before the tribunal. You have become wiser after the suffering of order.
Maybe, my lord, because some of the counsels are in tribunal. It also filed prior to my joining. Yes, it is.
Now, question is, to bring it under the doctrine of fruits of the poisonous tree in American law, they say, fruits of the poisonous tree, whoever eats will die. Whether he has grown that poisonous tree or not is another thing. To bring it, the case of the applicant, the employee under that doctrine, there are conditions. One condition is there should be some complicity. There should be some complicity. Number one. Number two, another aspect. Now 3 months were remaining there. There is no culpability attributable to the employee. If at all she is an employee, she is not employee at all. And she is engaged there, therefore I call it her employee. She is not a civil servant. Admittedly, she is not a civil servant. Is it?
Yes.
Not a civil servant. Number one. Number two, when the appointment order was issued, that is 9/6/2014, she was 17 years, 9 months. All right. This, before she attained majority, you should have taken the action swiftly. I told her to quit the employment. Because once a kind of engagement takes place, a sort of status arises. Now, if you remove, tomorrow, she will not be able to buy the milk and vegetables from the vendors, saying she has been removed, and the whole village will treat her as dismissed employee. So a kind of potential stigma attaches to her. Though not actually stigmatic, but the very default attributable to the girl.
Well, in this context, she came to know that this thing happened. On 19/4/2016, she submitted an application representation to the authority. Chief Postmaster. Saying this, that I am filing an application and my case may be considered and regularized. All these things.
When she made the application?
That is application page 34.
When it was made?
It was submitted on 19/4/2016.
19/4/2016.
Yes.
That pales into insignificance.
Yes. And that representation was also considered by the CPMG as an order on page 30, Lordship may see. The detail order, it is a speaking order. Against that, he has approached to the tribunal.
Not like that. Where a person is appointed, having not attained a majority, which is the prescription under the rule, if you want to remove, you should start action before attaining the majority. You cannot sleep over the matter till she retires, till she gets children, grandchildren, and one fine day waking up from the slumber.
But it is not
the action.
It is not the case. It is a case after her joining, because it is a peculiar post is that she will arrange a house for post office. She will get that's why a letter of Lordship may see. I'll show you. This appointment letter was not given. It is given. You arrange a house in Gramin post office. They have taken a house house from a particular village, and this whatever minimum rent there, the post office will bear the same. He acted as a Gramin postmaster. A girl at the age of 17 years some more and appointed as a postmaster in the post office, and she has started functioning. There must have some thing is coming to this villagers or somebody else. He has given a report to us. Then only authority is given inquiry. Without inquiry or without verification, we can't take any action.
Where is the guilt attributable to the girl? What? She is a young mind. What she will feel? But you are quoting rule.
Yes.
But rule, you cannot put it as a butcher. You have to put the rule only as a sanction.
But we cannot say, suppose I am putting question to myself, before submitting any application, it is not my paramount duty to submit application what the minimum is.
It is your duty.
It is my duty.
Yes. Because after submitting the application, everything happens in the indoor. That is called the doctrine of indoor management in company law. She will not be able to say anything. She said that I want job because many jobless people are there. Therefore, everybody aspires for a job. She applied for one. She produced the SLC marks card. Marks card stated what is her date of birth. It was for you to take a decision whether to grant appointment or not. After ascertaining whether she has attained majority, not even majority, more than 18 years. Your rule says 18 years and your advertiser says more than 18 years. Anyway, we will not bother much about that. Even going by rules, there is no culpability on her part, number one. Number two, there is a belated action because you are taking action after she attained the majority. There is no complaint against her about the working. Any complaint? No. Now she has attained majority. Therefore, suppose she had married before attaining the age of majority and begotten a child. If you were to cancel the marriage on that ground, the child becomes illegitimate. More or less, this case is like that. Union government and its entities are knocking at the doors of the court for assailing the order dated. Sit down and say, kindly sit down. Kindly sit down. It's not a primary school, we are all equals.
D1 2019.
Huh?
3rd January 2019.
2019, whereby appellant OP's OA number 496 of 2016 having been favored, her removal from service came to be set at naught with a direction for reinstatement. First off, next paragraph. Learned DSG, Mr. Padi, in his usual vehemence, submits that as on the date the appointment order was issued, namely, that is 9/6/2014, the OP had attained only the age of 17 years and 9 months, the rule prescribing 18 years. First up. Therefore, on coming to know of this information, the OP has been removed from service after giving an opportunity of hearing and also after rejecting her application for regularization. Wide order dated. What is that order? You said regularization seats are for and you rejected it.
My lord, pardon my lord, the termination is without any notice or without any opportunity.
His contention. Yes. Regularization order. Yes.
But here's Lordship wants to know the date of appointment.
Date of appointment, I know, 9/6/2014. Yes. You say her application for regularization is rejected.
The order of termination is.
Therefore, you should bring bomb sheet. That culture is not there here.
Page 22.
All dates should come in a form.
Yes. Make it date. Page 22, let's say advertisement. Yes.
Council submits that. The DSG submits that the prescription of minimum age limit under rule.
That is GDS rules. Basically, GDS. This book
GDS rule. GDS conduct.
That is my lord, pardon my lord. That is not under GDS rule. It is method of recruitment of GDS. That is
rule.
Yes, my lord. That is a yes, my lord. That is a instruction issued by the rule.
Rules cover everything.
GDS conduct and engagement rules.
Yes, that is not in there.
Engagement.
That is no. London Tribunal has observed.
Under the extant rules, the minimum age limit for seeking public employment is 18 years. Even the advertisement dated.
Advertisement 14/8/2013.
14/8/2013 had specifically mentioned that the aspirant should be above the age of 18 years.
More than 18 years.
More than 18 years.
Sub age, yes.
More than 18. First off. That being the position, the order of the CAT setting at naught the removal is unsustainable. First off. Learned counsel appearing for the OP vehemently opposes the petition, making submission in justification of the impugned order of the tribunal and the regions on which it has been constructed. First off. He adds that the removal of this client from service, if at all it is a public service, is without any opportunity of hearing, and therefore, being in violation of principles of natural justice, the same has been found fault with by the CAT. First off. So contending, he seeks dismissal of the writ petition. Next one, having heard learned counsel for the parties and being perused with the petition papers, this court declines indulgence in the matter, broadly agreeing with the reasoning part of the tribunal, and also for the following reasons, additional reasons. A. The OP's date of birth is admittedly 7/6/1996. Semicolon. The advertisement was issued on 14/8/2013, calling for application for engagement. First, OP had stated their claim for engagement by producing all necessary documents, including the matriculation certificate, which reflected her date of birth clearly. First off. After looking into all these documents and considering the candidature, OP was issued appointment order on 9/6/2014. First off. It is only on 18/4/2016, the order removing OP from engagement came to be issued. First off. Thus, as on the date the removal was effected, OP had already attained the majority, and that there is no complaint whatsoever against the discharge of OP's duties. First off. Thus, there is absolutely no culpability attributable to the OP in any way. First off. Next paragraph. In the matter of engagement, while all documents are produced by the aspiring candidates, the process of engagement takes place and the doctrine of indoor management comes into play, since participation of the OPs at that level is not indicated here. First off. It is not the case of petitioners that OP had committed any fraud or fabrication or any act tantamounting to suppressio veri suggestio falsi. False. First time. It also cannot be assumed, even for sake of the argument, that OP had suppressed her date of birth or had given a wrong date of birth, either, in as much as OP had produced the matriculation certificate, which the apex court of the country in a number of decisions, in a catalog of decisions, has held can be the proof of age of the candidate. First off, for the fault of the agencies involved in accomplishing the engagement process, the candidate innocently engaged cannot be put to prejudice. First off, the fact that the official who had granted appointment letter, even when arguably the OP was not entitled to 1 comma, has been punished in a disciplinary inquiry, does not advance the case of petitioners to the detriment of the OP. First up, guilty party is punished and right thing has been done. First up, therefore, non-guilty party cannot be punished. Whether in Mr. Padi, when taking the disciplinary action against your official, did you involve this candidate?
No notice was
No notice was It is more so because in the disciplinary inquiry held against the official responsible for giving appointment, comma, no notice was issued to the OP, and no opportunity of her participation in the said inquiry, comma, be it as a delinquent or otherwise.
That is not known to me, actually. I do.
No, but you have not pleaded.
You have not pleaded.
It's not, but therefore we say it that way. Yeah. Okay. First. An innocent party of fraud and fabrication stands on a different footing, was a perpetrator, said the Privy Council more than a century ago. First up. Next paragraph. In the above circumstances, this petition being devoid of merits is liable to be dismissed, and accordingly it is. Costs having been made easy. Are you reinstated now?
Pardon me?
Are you reinstated in service?
No.
The OP shall be reinstated in service as before within 6 weeks, and a compliance report shall be filed with the Registrar General of this court, failing which the petitioners run the risk of contempt action, which may be serious.
Item 26.
Ninth Division of.
Yes.
Petitioner. Unless the order of bar by on a tribunal order unless was bench.
And one sentence shall say. Yes. It is noteworthy that even in industrial employment, persons below the age of majority is employed, subject to the rider that such employment shall not be hazardous one. Just put that one sentence.
Yes.
Yeah.
Item 26 were the
26.
opposite parties now. Completely clean, but this previous councillors transferred the brief to us after joining the state final. So let's keep it to any next week.
Week after next week. You said 2020 matter.
Yes. Let's keep it 7 days time.
Week after next week, the request of learned DST finally. Yes.
Item 27.
Yes.
There are 2 matters. Let this matter list along with the WPC OAC 444 of 2021 that is required for reference. WPC.
It's a similar matter.
No, it's not similar matter. Yeah. My claim for regulation has been rejected by the tribunal.
No, let us see. I'll come to you. Yes, yes, sir.
My lords, after the rejection in SAT, they have filed another writ petition here. And there was an order to consider his case. In this writ petition, that order was passed. What I pray, my lords, let it be listed along with that.
Tomorrow we'll list all the
yes.
And solve this matter along with the WP number.
WPC within bracket OAC 444 of 2021. My lords, next week.
Next week. Yeah.
Item 28.
Lord, I have a small prayer.
Yes.
Well, in the connected case, that is in WPC number 27979 of 2022. That is a single bench matter. But
That is
since,
single bench.
yes,
It should be.
but since the division bench matter is pending before your lordships, therefore your lordship has tagged that matter with this.
The Chief Justice is.
Yes, that is there. In that case, interim order was passed that I may not be disengaged from service. I have rendered more than 26 years of service. I have approached for regulation. My case for regulation was rejected by the SAT. Thereafter, again, I approached this honorable court by filing a writ petition indicating subsequent development, and your lordship directed for consideration of my case. That was rejected. And when they intended to terminate my services, I approached this honorable court. This honorable court directed for passed an interim order on.
My lords, this is single bench. Please 1 minute.
On 28 May 2022.
There was no Chief Justice.
So that was tagged 28 May 2022.
What is the noting?
No. 28/10/2022, your lordship passed an interim order.
Not assigned.
But your lordship may kindly see the
Where
first
is the
order.
order? See, learned single judge white order dated 24/6/2024 asked the registry to take order at the hands of Honorable Chief Justice and post it. Where is that order?
But thereafter, the matter was posted on 4/12/2024.
Whether there is a Chief Justice's assignment order?
Your lordship may kindly see the subsequent order.
Who passed that order?
For a division bench.
That referring to Honorable Chief Justice's allotment. 96 Supreme Court says, unless the Chief Justice allots the matter, the bench has no jurisdiction at all.
Your lordship may kindly see that the noting of Deputy Registrar dated 15/7/2024.
Yes.
Minutes of the Chief Justice. It is there.
Yes, there is an order by the Honorable Chief
It is
Justice.
there.
It was not reflected in
that factor.
No, that might.
But it's there, we saw that.
Well, my submission is, well, since they have violated that order, that interim order, I have filed a contempt petition also. That contempt petition has also come. Well, after rendering 26 years of service, well, they are not allowing me.
I will tell you one advocacy. Where order of the Constitutional Court is not followed, you can argue that they should not be heard in the matter. Make best use of it.
Yes.
Simple.
Yes.
Next week. Next. If they don't obey the Constitutional Court's order,
Yes.
any order of any court,
Yes, I will
we will not hear them at all.
Yes, I will take that.
Yes. You take up that contention.
Item 29.
28 minute, I play for.
28, you are appealing.
I am for the opposite party.
28.
Milord, I am for the petitioner.
Why are you calling 29? Are you not tick marking your list?
Milord,
Yeah.
kindly see the order dated 12/3/2024. It is against the CAT judgment, that order. Already. Already 2 years passed. Milord, the only question here is that the land tribunal noted down the decision cited by the petitioner and grounds taken in the petition and passed that no, these questions are not applicable without analyzing the law.
They are not applicable.
That is, Milord, your lordship, that is reflected from the judgment itself. Milord, Annexure 25.
What was the case before the trial?
It is a disciplinary proceeding against the petitioner. Milord, the case is that he was charged of a stock, Milord, charged of a department where the stocks are there.
He was in charge of stocks.
Superintendent of in charge of stock, Milord. He found 3 items are missing. So he reported the controlling authority. Controlling authority asked explanation.
And after receiving explanation, he initiated a disciplinary proceeding against 4 persons arising out of the same,
including your client.
The proceedings were separately conducted.
It was not a joint
individually, not common proceeding or joint proceeding, nothing was done. Rule provides if on a particular incident, if there are more than one person involved, there may be a common proceeding or joint proceeding. The authority, the
disciplinary authority has to
highest
take a
authority
call on
is same. That also not followed. Cryptic order passed appellate court, not taken into consideration.
Let us go to the foundational facts now.
But may I pray, my lord? I am not there. I requested yes, my lord. I requested my honorable senior.
When will you argue them?
1 week after any date, my lord. Because it is sent to the mediation center. That has been paid.
Miller, may.
I'll fix a date now. On that day, he has
only this is the point, Miller. No purpose will be served. Only thing is, Miller, your lordship kindly see that particular.
No, your friend wants 1 week time, even that you are supposed. Call this matter next week at the request of learned counsel appearing for the office.
Office, man.
Office.
Your lordship, 2020 or 22, any date.
Whichever date you choose, that date only will come. That date you have to argue the matter.
Yes, man. On 22, man.
22nd. 22nd. 21st already?
Yes.
21st.
Yes. The first ever I approached my learned senior.
I told because it can be disposed of because of that, Miller. No analysis.
It is
nothing.
not incorrect on my part that I
Item 29.
senior counsel is sitting here.
2 years forward, that's why I made mention.
Both you can go for, both you can go for coffee. Here, which is yes.
I am serving in the counter in that item 29.
In the meanwhile, it is open to the office to find the counter if any. So.
Item 30.
I am on behalf of the opposition party, my lord. Department is filing the case against
my lord. Directed to examine the Supreme Court and other judgments.
Yeah.
And Janki Raman case onwards.
94 Supreme Court,
Yes.
95 Supreme Court.
Yes. Then we observed from this examination, only point we have that they have taken an interim order on 2014 with the Calcutta for 5 weeks. Thereafter, it may be a mistake or whatever may be observed, the department has not taken any action. Taking advantage of them, other side also file a application for promotion to Joint Commissioner. But dispute start from the External Commission onwards. Now question is here, whether the order passed by the tribunal can be sustained in the eye of law or not.
What was the fact matter before the tribunal?
My lord?
What was the fact matter, foundational facts before the tribunal?
This page 124, it starts from 123, page para 11. Internal para 11, 123, internal page 15 of the orders and continuing page 123. Besides the above, it is not it is not out of the place to mention that according to the respondent, the department, the CBI was also instituted against the applicant on 12/11/2008, but there was no progress till 6/1/2014 for the near about more than 5 years. And on 6/1/2014, the criminal case was stayed by the Hon'Ble High Court of Kolkata only for a period of 5 weeks. Thus, there is no progress from 12/11/2008 till the date of promotion order was issued in favor of the juniors of the applicant on 31/12/2013. Even till the date of CBI case is still pending without any order of stay by any higher forum.
It was a case of sealed cover.
Yes.
Sealed cover.
Yes.
Question is, how can you keep something in the sealed cover? How long? Eternally? No. The stay was for a short period.
Yes.
Why you did not take any action thereafter?
That is a mistake of us.
Then how can you interpret?
That's why I'm not pressing many things, my lord. I maintain myself, and I found that this is the lacuna has been done by the department.
The petition is dismissed on the ground that the sealed cover procedure being an exception, claim of a candidate put in the sealed cover procedure cannot be eternally put in abeyance, as held by the apex courts in Nihar-Ranjan Chowdhury versus State of Odisha. The apex court judgment was this court. It was the judgment of apex court.
Apex court judgment.
Which is that judgment? There is a famous book unsealed covers.
India was a Dolly Lolly case. Dolly Lolly.
Recent case, Dolly Lolly case. Yes.
Do that.
Yes.
Sorry. The CBI case in question was stayed by the Calcutta High Court only for a period of 5 weeks. 5 weeks. 5 weeks. 5 weeks.
But thereafter it was not extended. It is not that.
And the stay order was not extended. Nothing happened for about 5 years or so, as has been observed by the tribunal at paragraph
10 and 11. 10 and 11.
11. At paragraph 11. First off, therefore, the tribunal directed grant of promotion to the OPs after opening the sealed cover. First off, this cannot be faltered. But that will be subject to outcome of suppose whatever promotion is to be given to your clients. That will be subject to outcome of the case now.
Yes.
Yes. Whether CBI case is one thing.
No disciplinary proceedings there.
No disciplinary proceedings. But even then it will be subject to the CBI case.
Yes.
We make it clear.
No disciplinary proceedings started.
But he is superannuated by now. Already he has got retirement.
He has already retired from service.
That makes no sense.
72 years old.
Dismissed.
Generally, the impression is the official that got this stay order, it is continuing. By that impression, department is going up.
But they initiate proceedings against the said officers.
Charge issued after the deposition.
Next.
Item 31.
May I please your lordship?
Yes.
The state has preferred this appeal that there is 800. The state has the appeal and there is 839 days of delay. And the circumstances why the delay has been, it has been mentioned that the Honorable Single Judge has disposed of the writ petition with a direction that the petitioner, the service of the petitioner be regularized from the date of initial appointment and to pay all service benefits to him.
He has retired already?
No, my lord, he is in
employment.
He is in service. But that order was passed on 36/2023.
OAT. Orissa Administrative Tribunal.
That has been transferred to before this honorable court and it has been
disposed of by this court.
Mine. So the fact remains on the date of passing of the order, the petitioner service has already been regularized.
Which is from?
Regularized from
Date of entry.
Regular, yes.
With retrospective effect from the date of entry.
My lord.
Now what is that you want to tell?
So what happened, my lord? So after passing of the order.
When you had regularized the services?
But that is 18/3/2023. By issue of,
Before issuance of your writ petition came to be allowed.
yes.
Then petition should have become infructuous.
No, my lord, what happened?
Yes.
The order has been passed. My lord. So since we have complied with the order, so nothing remains to be done. The petitioner has filed, the respondent has filed application for contempt for violation of the order.
Yes.
So that contempt application has been disposed of on 19/12/2023 with a direction that the order of this Hon'Ble Court be complied with within a further period of 1 month.
One more month gave.
Yes. That has been disposed of without any notice. So that order has been examined afresh by the present respondent, appellant. And again, after 1 month, the respondent has again preferred another contempt application, which is now pending for violation of the order of the Hon'Ble Court. In that contempt application, the state has filed a reply affidavit stating that the order has been complied with by producing that order dated 18/3/2023. The service of the petitioner has been regularized, so the order has been complied.
Regularized and consequential benefits are granted.
So consequential benefit as per the rules that has been granted.
Granted?
Yes.
No. Not granted.
No. So,
what are the consequential benefits granted? Show this.
So, the order says, Honorable Single Judge has held that the service benefits as admissible and due shall be paid to the petitioner. But prior to that, that contractual appointment rules has been repealed. In view of repealed rules, in view of Rule 4 of the repealed rules, whatever the petitioner is entitled to has been paid. But what happened, my lord, here the petitioner was appointed under a RA scheme. What his initial appointment was made.
Rehabilitatory assistance.
Yes, rehabilitation assistance scheme. But his appointment was made contractual because in the meanwhile, at the time of appointment, the relevant rules for fill up the group D and group C and group D post is contractual. That is CA contractual appointment rules. So that order he has challenged before this Hon'Ble Court. And before passing of the dispose of the writ petition, the rules has been repealed, and in view of Rule 4 of that repeal rules, the benefits has been granted. This is the affidavit.
What Rule 4 says?
But that Rule 4, I have annexed.
What is your case, brother?
My lord, I am the respondent number 1 here. My lord, I was before the tribunal. The said OA was transferred to this Hon'Ble Court, which was adjudicated by this Hon'Ble Court, and the order was passed on 30th June 2023. And that too, that order was passed on the premises that another adjudication was made by this Hon'Ble Court in order dated 22/3/2023 in another case. 22/3/2023 in another case.
Similar case.
Similar case.
That was what WP?
That was WPC. WPC OSC 2006/2017. And there, my lord, the order itself passed in my case, so far as my case, was on the basis of the concession and the admission made by the state respondents that my case is covered by the other judgment. other adjudication. And everything took place after the so-called regulation was made by them on 18/3/2023. My lord, may kindly bear in mind.
No, 18/3/23 is prior to 36/20.
Yes, as well as 22/3/2023.
Earlier, another
the other judgment. So the state council who appeared before this honorable court participated in the process of adjudication, while my case was adjudicated by the honorable single judge of this honorable court, accepted that the other judgment passed by this honorable court
covers your case.
It's my case. Accordingly, my case was disposed of
in terms of that order,
in the light of the same order. And my humble submission is the other order passed in the other original application still remains as final without being challenged. But here they have preferred this on the plea that this development has taken place. My lord, here the main issue is because of the misconception under which, if I can say so with the lordship's permission, the state is reeling with. My lord, may kindly see my appointment. My lord, since your lordship always go into the foundational fact, my lord, it is my duty with your lordship's permission to bring the foundational fact over here. My lord, here is a case. My appointment was based on made on OCS, Odisha Civil Service Rehabilitation Assistant Rules 1990, which is a rule under 309 of the Constitution.
Proviso to
309 of the Constitution. And the very same rule, at Rule 18 specifically, gives it overriding effect over any other recruitment rule. The rule which
he is saying to these rules.
That is a recruitment rule, which is a general rule, and I have got myself appointed under a special rule. The fundamental difference which they fail to understand is that a special rule always takes precedence over a general rule. One. Second thing, they based.
That was not never before the honorable single judge.
What is the order which you are challenging?
Sorry to interrupt your lordships. My entire case before the honorable single judge was, I was challenging my own appointment order made in the year 2018, relying on that rule.
You should have been appointed on regular basis.
Yes, my case was I should have been appointed under the OCS RA rules 1990 in terms of the direction given by this honorable court, while confirming the order of the tribunal in the appeal preferred by the state, which the state has lost. I am repeating with your lordship's permission.
Necessary.
So the state has challenged my.
There was an order by the Orissa administrative
tribunal,
which was beneficial to you, though it was in some other.
Appointment under OCS rules 1990.
Not to you, to some other person.
No,
you only had
yes, I approached. I myself. It's a specific adjudication between the parties. I was before the tribunal challenging their action. The tribunal said that I should be given appointment under OCS RA rules 1990.
OA number?
OA number, that is OA number 3351C of 2017, and the order of the Hon'Ble High Court are here. Sorry. One is 2030. Sorry. One is OA number 2030C of 2016.
1 second.
2030 of 2016.
Disposed of on 4/8/2017. And another OA is OA number 3351C of 2017.
516.
3351 bracket C. E for Kotak. C stands for Kotak.
Kotak batch, right.
Kotak batch of 2017.
This was for what? This was to make appointment on regular basis.
Yes, my lord. That order itself is available on record.
One second. The another OA is 12030 of 2016 is what?
That was challenging the rejection order passed by the state authorities on the ground, saying that when your mother is available, how could you make application for appointment under rehabilitation? Since that was rejected, I challenged it before the tribunal. Tribunal hold that yes, I am entitled to be appointed under the OCS RA rules 1990.
1 second. That was 4/8/2017.
Yes, that was the first one. That was the first one.
1 second. Slowly.
Sorry.
The 3351 of 2017 is disposed of when?
3351 of 17 was disposed of on 8 December 2017. Holding that I am entitled to be appointed under OCS RA rules 1990. Your Lordship straight away go to page 62 of your Lordship's brief. The order of the Honorable High Court is there. Both the orders are there, which they are duty bound to implement.
Now they have challenged a learned single judge's order.
Mine.
Now after these two orders of the tribunal,
confirmed by the Honorable High Court,
and the OA 3351 of 2017 is affirmed in which writ petition?
My Lord, the WPC 147154 2018, page 62, that is the order. Order available.
Kindly repeat.
14715 of 2018.
14715
of 2018.
18 disposed of by DB.
Yes, my Lord,
DB disposed of on
14/8/2018. Page 62 of the brief.
What they said, they upheld the order.
Yes, they upheld the order.
And dismissed the petition.
Yes.
That's all.
That is the appeal preferred against the order of the tribunal.
Yes.
Directing for my appointment under OCS RA rules 1990, that was dismissed. Compelling them, since they didn't challenge it before the Honorable Apex Court, to give me appointment. Now that led to my order of appointment, which was issued on 13/12/2018, with all these conditions that again, they virtually take out.
13/12/2018.
Yes, page 63. Your Lordship, kindly see.
63, Your Lordship.
Page 63 is my order of appointment.
You are aggrieved by which order?
That the annexure 2 at page 77.
Annexure 2, page 77.
Yes.
This order.
That
order directs what?
Directed for my
written petition has been disposed of
for
in the
my
light of the judgment delivered in another case, not batch of writ petition.
Where
That
you
is under
agreed
annexure 3.
You agreed that it is covered by that judgment.
Yes, my Lord.
Annexure 3 judgment of the Honorable Single Bench.
Para 5.
So Lordship, kindly see the last portion of the order.
Mr. Mapti, you have filed that cat? No.
My Lord, the writ appeal has been filed by...
I know, but...
my Lord, I have not, with your Lordship's permission, I can very well file.
No.
My Lord, here, my Lord...
Because they may escape some date.
Yes,
Call it day after.
My Lord.
Day after. You file
Your Lordship, as per your Lordship's convenience, my Lord, I have filed my objections to the condonation of delay application of around 879 days. My Lord, by bringing just no, in view of the latest judgment.
Peace has pointed out.
Yes, correct, but there is a latest judgment.
Yes, I have
gives the reckoning date.
Yes,
limitation.
My Lord, I have objection that judgment of the Apex Court in that Sivan date through LR versus Karnataka Housing Board.
Yes, yes. You produce your calculation.
Yes, that is what I'll draw. You draw your Lordship's attention at. If your Lordship will see, I have given the entire judgment. I have given the
your calculation.
That's all right.
Your delay.
Now, if too many dates are involved, I only have noted 7 dates now.
Now we are also.
So you date chart.
My Lord, I will give
short note as against the date.
My Lord, I have also. My Lord, I will give.
That becomes easy.
Yes, my Lord, I will give. My Lord, only thing, if your Lordship permit, my Lord, the case stands on a very narrow compass because.
No, anyway, since you are agreeable with your proposal, you need not be on your feet at all.
I have also filed a preliminary objection regarding maintainability of the writ petition.
Yes, right.
All these petitions have been filed because the Honorable Single Judge is now directed the personal appearance of all these persons.
So that is why I am pressing lot. I am.
So that is why they have
after 900 odd days.
900. So they have
my only prayer is, Lord, at this moment, my only prayer is, your Lordship may protect those two.
No protection. They should be arrested.
But at least, Lord, in the
content,
my Lord,
coordinate benches say again time is granted. Can it be done in contempt?
No, my lord.
It only the writ court can do.
Respondent knows that the
That's all.
writ appeal has-
Let your officers be arrested. When it is posted, I'll call this afterwards.
That was posted during this week, 12 to this week commencing 12 to 16. So it is up to your lordship.
Heard both the sides at length. No case is made out for granting any reprieve in terms of application moved by the government in its writ petition number so and so.
Writ appeal.
And therefore, we don't interdict the content proceedings. Let them be arrested. When it is posted.
We commencing 12th of January, 2026. This week.
This week.
From today itself.
So lordship is special in the writ appeal.
No case is made out for granting any interim order.
No, lordship not had me. It is his case.
No, now we heard.
It is my appeal.
Your appeal.
So yes.
But you have made application for interim orders.
But why I am making that application?
We are not granting that.
Sir, I am not praying also. Your lordship may pass, may not pass. That is your lordship. But what happened, my lord? He knows that a writ appeal has been filed.
Correct.
And order has been complied with. And pressing the contempt application.
Why we should entertain this plea? It is for that court. Contempt court will decide that.
Yes.
We have no jurisdiction over that.
Yes.
We are only saying for interdicting contempt proceedings, we have no power. No case is made.
So such a request made by the respondent, I have never made.
For stay of the
After that, since your lordship dictating the order, then I submitted.
Recall that order.
Yes.
Heard learned government advocate, AGA?
No.
Your
Panel
counsel appearing for the petitioners and learned counsel appearing for the OP.
I am for the pro forma respondent number 2.
Full stop. Have you anything to say?
No.
Mr. Panda appearing for one of the, Mr. Panda submits that he represents
Pro forma respondent number.
Pro forma respondent
number 2.
Respondent number 2, and that he does not have anything to say in the matter. First up. Next paragraph. An application seeking condonation of delay, long delay of 900 odd days is moved, supported by an affidavit. Another application, which is that IA?
IA at flag B.
Another application is moved seeking stay of the impugned order. First up. Though we heard learned yes, standing what is that?
Yes.
Standing counsel transport.
And so for length, we are not convinced that as of now we are not convinced that either the delay should be condoned or any reprieve should be granted against the impugned order. First up, we know that the contempt proceedings are pending before the learned single judge for non-compliance of the impugned order. First off. However, beyond saying this, we do not do anything. But call this matter in the last week of January.
Lordship.
Yes.
Lordship may hear this, my condolence. Otherwise, the person will put behind the bar.
Yes, it should be. 900 days, 900 odd days delay.
Yes.
Why we should condone the delay?
Oh, Lordship may hear me. Why this delay, my lord?
We have heard what is.
No, my lord. What? After the contempt, Lordship kindly see the impugned order and Lordship kindly see the compliance.
No,
so if the person, bona fide office.
Compliance has to be shown elsewhere.
No, the order has been complied with.
That court will appreciate.
How we will decide that?
If complied,
that case is not before us.
So if your lordship not then have the order has been complied with or not, and there is intentionally delay in not complying the order, then only your lordship may pass any order.
Now, how they can
so it is in bona fide
to pass.
But it is our bona fide that we have complied the order.
No, you should say.
So since the order has not been complied and the order in terms of the order no action has been taken, the honorable single judge has pointed out, then the appeal.
Mr. Counsel, you are saying that you have already complied the order.
They are not in delay in filing because of this. My lord, there is a delay.
No, that we are not. That therefore you tell it.
Your lordship, yes, that is the only ground. That is my only ground. On our bona fide, we have complied the order. Since the honorable single judge has pointed out that this is not the compliance, then this writ appeal. Otherwise, there is no malafide or.
On which order you are on writ appeal? Which is the order which you have impugned?
Annex 2. Annex 2, my lord, at page 77.
They say before the order was passed.
Just please.
Please, while I am arguing,
supposed to order him. We are here.
Yes, my lord.
You can, brother, you can address the court. You cannot threaten him. Take your seat.
Mine.
Sit down.
Mine.
Sit down. You are not supposed to threaten him.
While I am submitting,
you to address him.
No, I am before your lordship, your lordship.
You are not made a judge as yet. I am not sure that you will be able to.
That cannot be done.
Then sit down.
Mine.
How can you threaten the advocate like this? Merely because you are a government advocate. Do you come from the heaven?
No.
Sit down.
Mine.
Sit down first.
Mine.
No standard. You are not supposed to threaten the advocate.
Mine.
He is appearing for a private party.
But
he is not at your beck and call.
But my only submission is, while he is submitting,
why are you raising your voice against him? Who are you to address him?
I am submitting his.
That's what you can tell us.
So if that is allowed,
you do not have ethics and fellow feeling.
So everybody start doing merely because you are government advocates. You are not superior to these people. At times I consider government advocates as inferior to the private advocates.
That's right. I am not superior.
You are not superior.
No.
Maybe inferior compared to him.
Yes.
But anyway, we will not say beyond that.
I always.
You cannot threaten. You cannot threaten. You cannot dictate.
Sometimes, Lord, I learn from him.
You not sometimes. Many times you have to learn.
Yes, Lord. That's right.
You cannot threaten like that. How they should conduct the case? Suppose if he threatens you.
Kindly see the Annex 2.
No, brother, you should not do like that. So he does his job. He comes with lot of preparation, with all job chart and everything. Yes. We'll have it tomorrow. Suppose if I pass order, he thinks that in anger we have made the order.
No.
It is up to you. We'll have it.
No, Lordship may. No such.
It is always wise to be taken tomorrow.
We'll so that
I am sorry, my lord. I am
so extremely sorry. Happens, but see, they are all officers of the court. You are all officers of the court.
Yes, but I am extremely sorry, my lord. I am extremely sorry because since morning, my lord, I am here and I follow your lordship. So I am extremely sorry. Lordship may.
Sorry, forget everything.
My lord, may.
Yes, we'll have it. When the contempt matter is coming.
This week.
This week it should not come. We have this matter next week. Till next week, don't precipitate the contempt.
Your lordship may call this matter tomorrow. And I will come with that. I will come with that date chart. Your lordship may take up this matter, decide on merit.
Day after we'll have.
Because he is
holiday.
Tomorrow your lordship may call it. I'm ready.
Tomorrow we have other matters.
On Thursday. On Thursday also I am ready. Madam, I have prepared that notes for myself. I will just make it final and provide it to your lordships. Madam, I was startled to accept this contention that the order the impugned is 30th June. They say it was complied prior to that.
Now one more thing. If there is anything to be complied.
Independent. That is independent compliance. That
Anyway, what is to be complied, what all should have been given to you, just bring some
yes, ma'am.
So that we can tell.
The only thing is, my lord, it is because of the determination that we will not comply with the order. That is why they are pursuing. Madam, I'm explaining.
Don't be judgmental to it.
No, I'm explaining. Madam,
Mr. Marty,
yes, madam.
Please hold. as you have said, only submit.
Yes, ma'am.
Only submit the jet chart.
Yes, future, submit the till then you don't precipitate.
As it appears, both of you were waiting for the matter to come, and still hangover is there. Please overcome this back.
Only some around 2 lakhs, which your lordship can very well decipher from the order at Annexer 5 itself.
We will do that.
Simply to give it in actual terms.
We will call this matter next week. In the meanwhile, don't press the contempt matter. Nothing will happen.
No, I am not
deciding.
I'm not going to press.
No, but court should not call officer. You have seen the latest judgment day before yesterday.
My lord, I am not, my lord, whatever your lordship discretion, your lordship pass that order. The only thing I just, with your lordship's permission.
The AAC expresses apprehension as to some coercive action being taken in the pending contempt matter. First time. He need not have that apprehension since we are hearing this matter. We are halfway through in the hearing of.
He will request accordingly. He will make the request before the honorable if the matter.
First time. It is we request learned judge of the contempt court, not to precipitate the matter till next date of hearing. Let us.
Your lordship,
we'll call this matter next week.
Thursday, your lordship.
We do not know how many matters we have posted. The next week we are taking.
But can it be on Friday? Because this week itself.
Friday is.
As your lordship, subject to convenience. Subject to your lordship's convenience. Your lordship knows there is nothing to be.
Monday we'll have that.
Oblate.
Monday.
Oblate.
Brother, don't mistake us also. No, okay. We also sometimes exceed our limits when we see something wrong is happening in the court.
I'm sorry.
No, you have said that already.
He has succeeded.
No, he wants to protect his client's interest.
Yes.
Therefore, we
so I am
also say such a thing.
His clients are not my enemies, but he ultimately succeeded in his attempt.
Next.
Item 32.
Lord, I have challenged the order of the Learned Ombudsman under Annexure 4, my lord, denying to supply electricity, relying the decision of Casey Ninan case, my lord. Your lordship will find the order.
Casey Ninan versus Kerala said?
That says that when the land is transferred, or a house is transferred to some other person by way of sale or alienation or any, and if there is area outstanding, electricity use outstanding against the premises, the person who purchases in possession or occupation of the premises,
he will be
liable to pay dues, my lord. Here is a case, my lord. I am
in other words, the liability to pay the power charges runs with the land.
Yes.
Runs with the
yes. My lord, here, my lord,
yes.
Here is a different, my lord. I am the landowner. A portion of my land, in a portion of my land, my lord, a tower company has built a tower. Disnet Wireless Limited, my lord, for some years, my lord. He had entered into an agreement with the electricity supply company. Besides that, he has also entered an agreement with me, my lord. I am the landowner, and what are the terms and conditions? When he constructed the tower, he was availing power supply from my electricity connection, and thereafter he entered into an agreement with the electricity supplying company and available power supply. He paid the dues, my lord. My lord, during 2006, my lord, 16, my lord, in a cyclone, my lord, the power tower was demolished. Then, my lord, the company fled away. He did not pay my rent. Whatever agreed, my land rent, my lord, he did not pay me. Then I issued letter, my lord. Then subsequently, my lord, what happened? The structure was removed from my land, my lord, and then I constructed a shed over the said portion of land. I applied for supply of electricity. The company refused on the ground that there is area outstanding. But actually, there is no area outstanding. The tower company has paid much more. Even if after disconnection of power supply, company has paid few dues for few months, and there is no electricity consumption for the said months, my lord. But when
who is our opponent? You are here.
Then, my lord, I approached the grievance redressal forum. The grievance redressal forum order is under Annexure 2, lordship may have a glance. Lord, I may drop few lines to your Lordship's notice, my Lord. Paragraph 2, page 18, my Lord, running page 18, paragraph 2. The OP has intimated to the forum in this submission that the complainant, Mr. Dhirendranath Sahu, had executed a lease agreement on 14/4/2008 with the Messrs. Dixit Wireless Limited to use his plot number 480, khata number so and so for tenure for 12 years for the purpose of erecting telecom tower and associated equipments for cellular mobile services. Considering the above lease agreement as consent of the landowner, power supply was effected to Messrs. Dixit Wireless Limited on CD of 4 kilowatt GPS category. It is admitted by both the complainant that the OP and OP that power supply to the telecom operator has been long disconnected. However, the date of disconnection of power supply could not be furnished by the OP. The OP should not have continued billing of consumer after disconnection of power supply for more than 2 months. When initial agreement period is over, the EC will, with such fictitious bill amount after disconnection of power supply should be devised. The area dues of the telecom tower over plot number is recoverable by the OP from the present owner. When I am the original owner and there is no law to cast the liability of the tenant over a owner, Miller. Because I have never given any such consent or undertaking to the electricity company. If he will have any dues, then ultimately I being the owner, I will not be liable. This is not the transaction, my lord. Then, my lord, ultimately the forum has observed that the complainant is directed to clear all his area outstanding dues up to April 2018, my lord. Though the tower has been demolished in 2016, the consumer billing statement I have filed, my lord, annexure 5, my lord.
Tower is demolished when?
2016, my lord. Your lordship will find from page 45, my lord. Lordship may have a glance to page 45. The billing statement in my lord, September 2016. There was a disconnection.
Do you dispute removal of the dismantling of the tower in 2016?
That is at page 32, his own document. That is dated 13th April.
No, let me complete.
One second. We have to assert something.
Yes.
Or otherwise you will go on saying something which may not be true at all.
No, let me know.
13th April 2018
is the letter issued by the tower company to the present petitioner terminating the lease.
They terminated the lease.
This between us, he did not pay rent to us. Then we wrote letter to the tower company. Then he has written this.
This is the liability of the tower company.
Yes.
No, I'm asking you. Is it the liability of the tower company?
That's the electricity, the lease agreement between the person and the tower company says that electricity, the lessor is the lessor and the tower company is the lessee. Now the in the lease deed has been there in the lordship's document, and the lease deed in categorically 2 clauses says that the lessor will provide the electricity infrastructure. That means the transformer or the applications to be made. But the power supply agreement was executed between the distribution licensee and the DISNet. This
easy signatory.
He is not a.
No. He is not producing that. That is why your lordship's last order has observed.
Let him.
That is order.
But he is not a party to that. It's not a tripartite agreement.
It's not. It's not. It's a simple
between you and the
tower company.
Yes, the power supply agreement was executed between the distribution company and the tenant or the lessee in this scenario. It was there between them. Now, when we cross-check, the lessee was not there, and since 2018, as I showed it to your lordship's page 32. Thereafter, in 2023, there is a difference between 5 years. 2023, this person came for a new connection for the first time on the same premise. Now, the regulation says no new connection shall be given to the person unless the area amount is clear.
To whom it is to be given?
To the applicant, to the new applicant.
To the new applicant.
In this case, my lords, he came for a new connection in 2000, to be precise, 2nd January 2023. Correct. He came for a new connection. Our process as per the state regulation that we will process the new application on the premise if there is a due of electricity, unless and until that
Due
has
from whom?
Well, it's due, the electricity is due
In the
From the
premises.
power company.
No, the regulation says if it is due by, from the new applicant or in his spouse, or if it's a company he is associated with, or son or brother within the same discom or within the state. So, for example, Manoj, in Odisha, there are 4 discoms operating. If he has on the premise has got any due with respect
Let us read the regulation. Perhaps his case is for the dues of X, why cannot be made responsible, liable?
Yes.
That
And
will-
why I will be deprived.
And therefore, they cannot deny power supply to you on the ground that in respect of the tower, the amount is due and he has gone.
Yes.
You being the lessor, you should make payment and then you should see whether rule supports that.
Milord, other thing is most important. Milord, when there is no dues, suppose today line disconnected. Their duty or regulation says that for 2 months only, when the power supply is disconnected, for 2 months the billing will be done, charging the MMFC, and thereafter there will be deemed termination of agreement, provided the initial power supply is over. Milord, here is a case. In September 2016, the power supply was disconnected. Admittedly, the proof I have got, Milord, by filing the billing statement of the consumer. When the power supply is disconnected in September 2016, Milord, October, November 2016, there is deemed termination of agreement, and the record says that there is no advance of a meter reading. Milord, may see, have a glance to page Milord 45. Just a moment, Milord. Page 45, running page 45. In the left hand side, 9/2016, September 2016, there is actual consumption, ACT, and the advance reading is Milord 43359, 43357 advance. This much is the advance, 598 unit advance. And thereafter, in the month of October 2016, there is no meter reading advance, 43957, 43957. Milord, rolling down this 43957, they have stored some fictitious bills. And for 3-4 months, the company has paid. Without any consumption of electricity, there is no meter reading advance, Milord. And the company, if company will come, Milord, he will get refund of 54,000 from the company. And the GRF has said, as because the this tower terminated its agreement from the landowner, I wrote many times to the tower company, please pay my rent, agreement is in force. The company wrote that our agreement with you is terminated. That I have filed also. But taking advantage of that, they are not producing their agreement, what they have done with the consumers. And they are insisting, GRF has said that you pay the amount till 18. Though power supply was disconnected in 2016, Milord, the GRF has said that the complaint is directed to clear all his area outstanding up to April 2018 in order to avail new connection as per regulation 17.1 and 17.6 of OERC supply code.
Ultimately,
well, this is not applicable for me.
1 second. Ultimately, the question of law would be where the lessee incurs liability because of consumption of power supply.
Yes.
Power.
Yes.
Whether lessor's application for fresh connection can be denied or not is the question.
Yes, Milord.
That will be the question.
Milord, here, the license is TPCODL or SESU, SESU. The consumer is Dixit Wireless Limited.
Correct.
They have entered into an agreement, but prevents them not to produce the said agreement, Milord. And if at all there is area, Milord, the question would come. There is no area.
You have that agreement with you.
Yes, without agreement, no power supply can be.
How can you say?
Do you have a copy of agreement with you?
Malak's, my instruction was that since the power consumption was below 5 kilowatt, there was no agreement. That is my instruction, but I'm here to ascertain that.
No, without agreement, how much? You are supplying to the power company.
What I'm saying, in fact.
Standard agreement, that application form the standard agreement, Milord. For every person, Milord.
You have to permit.
In fact, that was initially I was waiting Then, my lords, in order to produce that agreement, I have already informed the TPCODL department that to decide this issue, and there was a direction that GRF also said that you have not produced the agreement. That is the crux of the issue, to answer whether there was a tripartite or it was in between, or what are the terms and conditions. They had asked me to seek time till 22nd so that we can produce. I had requested him on the other day that
you will produce it on 22nd.
By 22nd, I'll produce it.
Counsel for the panel counsel appearing for the power supply companies undertakes to produce the agreement between the company and the tower company.
Yes. Dixit Wireless Limited.
Dixit Wireless Company. First, non-production may result into an adverse inference being drawn against his client. You produce it. Simply.
Through what they have given.
In the absence of that also, we will presume that he is not a party to that proceeding.
Yes.
He cannot privity.
Yes.
He is not a privity to correct.
Yes.
His brother said that. There is no privity of contract between you and him.
Yes.
How can you deny the application for fresh application for supply is the question.
Absolutely.
And that is the only question.
In my limited submission, Malad, I have to only defend, because I am defending a couple of orders passed by GRF and Ombudsman. I will articulate my submission confining to what reasons both the forum below has.
There is one judgment of Karnataka High Court. I believe it is by Justice Kumar or somebody like that. Identical question is treated by Karnataka High Court.
In that case, in an case, everything has been dealt.
In Kerala judgment.
Yes.
Everything has been dealt. And while the matter was taken up in court number 5, my lord, the lordships have come to the conclusion that this judgment is not applicable to me because I am the owner. My lord, that regulation of which the GRF and Ombudsman has relied, that 17.1 and 17.6.
Yeah.
So it is for all in matter of transfer, alienation, every land.
Let you produce it on 22nd.
Yes.
Let us look into that.
My lord.
Because I have to also rely on that judgment, because the court below have cited
that judgment only.
And that is why your lordship by order.
It appears you have some difficulty.
Then your lordship have
observed.
That is why your lordship have observed 3-4 pages of our arguments made on that day by order 13/10/2025 after going through that case in Nan's case on that day, my lord.
Next.
Item 33.
Company is the been made sufficient, but there is no non-appearance from the opposite party. Private opposite party is involved.
Okay. He is not engaged anybody.
That is what Milats.
What is the case?
Let's hear. The only question here is, Milats, the consumer has a.
When the item delivered? When it was delivered?
They said to have delivered, not the date. Postal tracking.
16th July.
16th July. Any interim order you have sought for?
There is an. I've been.
You are protected.
I've been protected. Yes.
Till date or
until further orders?
Until further orders. Post after 6 weeks to enable other side to appear or make provision for appearance of representation. Yes.
In my case, there is an interim application. Subject to outcome of result of this petition, I may be allowed to power supply.
26.
Yes.
Suppose objected. I fairly.
Let him make payment subject to outcome.
Yes.
Payment, Miller.
You have to make the payment.
No, there is no error. There is no error at all. That is why I was saying.
Yes, now they are. Now they have to take a decision on that. You make a deposit.
No, there is no error, my lord. If there is an error, I could have paid without prejudice, my lord.
Not your arrears. Arrears of the tower company. They are saying
there is no error at all. I have.
But they have raised a bill, no? They have raised bill against the tower company. Outstanding of 3 lakhs.
Tower company paid away. There is no scope to raise bills. But the billing statement, billing is going on, my lord.
Let it come out. Next.
Item 34.
Yes, Mr. Padi.
Item 34, we have 3 applications. My lord, may take it next week because
Week after next at the request of Mr. Learned DSGP Padi. Yes.
the other council will pass on the slip, ma'am.
Which one?
That case, friend may serve, there are 2 annexary shortage.
They have already submitted. I got the copy. Compassionate appointment, only ground of rejection that your husband was regularized by virtue of court's order, therefore compassionate appointment will not be considered.
12th of February. 12th of February. 11th of February. 11th of February. 34. Yeah. 35.
Item 35.
Item 35. They have not served the copy of the original application and counter reply filed by them. Only file a memo. Without annexures. So let them file.
Give a full set of copies.
Yes.
I filed.
They are saying no.
You file a memo. I am not disputing this.
Give one more copy. Give one more copy.
Give the copy. We will file the counter also within a set.
Petitioner to.
Again, memo file to tasan annexor rahi.
One more copy you can give, na. Give one more Xerox copy.
Do you know? I mean, Xerox kar de do. We will make it Xerox.
They will make Xerox and they will give it back to you. Petitioner to serve a copy of the petition along with all the documents on the learned DST within 1 week. And the union government may file its counter within 2 weeks next following. Failing it, it will forfeit its right to file one first time. All after 3 weeks. 3 weeks.
Item 36, 37 have been adjourned. Item 38. Sorry.
Yes, brother.
Item 38, Mr. Khalid, my learned senior is on his legs. Is on his way.
Senior advocate appears in this.
Yes, ma'am.
All right. Week after next?
Yes, ma'am.
Any
opposite party files counter.
Counter is
Aims matter. Aims matter.
Counter.
You have filed counter?
No,
you have to file
counter.
46 times to file counter. Call after 2 weeks.
Entry model.
So you have entry model?
Yes, ma'am.
Call after 4 weeks, entry model to continue. See that? You see that, so they don't depend upon their version.
If the entry model there, then continue. Otherwise.
Entry made by Nepali is not considered at this stage.
No entry model granted. Call after 2 weeks. No entry model. Next.
Item 39.
My lord, in item 39, I am seeking time on the ground that my client had told me that he was supposed to deposit 45 to 50 lakhs towards the bank and negotiate a plan with them. But he has not instructed me whether the same has been done by him or not. Kindly give me 2 to 3 weeks time. I can get instructions whether the same has been conducted by him or not.
No, matter is in.
I got the respondent back. So already OPS which has been after concession has been given. And that has been withdrawn and concession has already cancelled. So as he has paid to deposit failed to deposit the first installment 60 lakh, and he has after he has taken time for 24 November, but he has failed on that day he has also paid. And in the court, before this honorable court, he has admitted that as the other alternative remedies there. He has also filed a securitization appeal before the DRT.
We have not filed the.
The petitioner has already been filed.
Borrower has filed that.
Borrower was paid for settlement of the after fail of the year, and he has filed the
Auction notice is already there.
property has already been sold.
Property is sold also.
Property has already been sold. Against that order, he has
Deposited 31 lakhs. He was supposed to get a subsidy from the government. There was a delay in getting the subsidy. That's why the payment.
Degree of contact between the party and the mayor for a year.
Almost on the verge of starting, he's willing to pay. I get some. That's why.
And there is a
You have filed a case before the DRT.
already.
One of the partners has filed. We have not. The
partner under section.
The guarantee.
Every partner is the representative of the partnership firm. See that
The
section.
guarantor has filed a case before the DRT as per my instructions that I know.
No. And previously, before the number, there is the order for submit.
I'm not sure. Kindly give me at least 2 weeks time. I'll get instructions from my client. Then the matter can be heard. Pleadings are always.
Place your client is from.
He's from Cuttack only, my.
Then wait 2 weeks.
After the vacation, we had not contacted.
Next week at the request of learned counsel appearing for the petitioner. Yes.
It's item 38. I'm sorry, Manas, I was 8. Well, just the matter before. I was on my legs. I just rushed to. It appears it is it took time. There's one issue I wanted to point out to your lordships, Manas. This order, Manas, this matter, the interim order was kept pending. Interim application was kept pending. Your lordship may kindly turn to the first order, 3/12/2025. The page 5, Manas. When we last.
Where are your opponents? Mr. Padi?
Yes, sir. So this was Mr. Padi was also appearing on the last date. Last but 2 paragraphs. When we inquired about the stage, that was the reason why Manas interim prayer was kept pending. When we inquired about the stage status of the departmental proceeding, no definite answer could be given by either counsel appearing for the parties. Therefore, prayer for interim relief made by Mr. Pali is not considered at this stage. My case was, Manas, that totally the whole thing was, charge sheet was without jurisdiction as P.V. Gopinath's case. And the rules also they provide. They have extensively, it has been quoted. Then Manas issue notice and Manas thereafter.
No, what they are doing now?
Subsequently, this stage we have inquired, we asked in RTI, the stage of the proceeding, that letter I passed on. It is at a preliminary stage, Manas, so Lakshmi may kindly appreciate. In inviting letter, inviting reference.
Statement is filed.
Manas. It's only at an interim stage.
Being placed before the disciplinary authority of VM Subhaneswar to take edition.
This is directly covered by Manas Sunny Abraham.
We have received a communication, I just pass up to my lord.
Yes. We have seen that now.
Same one. Same.
Still on further action under the provisions of the aforesaid rules.
Manas. So it's a preliminary stage, so that's why court was not sure as to what stage. Because it is
there are placed before the disciplinary authority.
Yes.
Presently. This was on 10/1/2010.
I leave it to your lordship, how your lordship will view it.
No, what do you want us to do now?
Interim, in the interim, let them stay their hands till your lordship decides the issue whether the charge sheet is without jurisdiction. It goes to the root of the matter.
Taken up the contention that the very issuance of the proceeding itself is in commanders.
That was the point. Sunny Abraham directly covers and
so you don't precipitate the matter till next date of hearing because you are seeking time now.
Yes, that will.
This court by the order dated 3/12/2025 that paragraph at ultimate and penultimate paragraph had said as under. First one. See those 2 paragraphs. Learned senior advocate appearing for the petitioner submits that now
the proceedings are placed at the hands of the disciplinary authority as is reflected in the letter dated 10/1/2026 issued by administrative officer of AIMS Bhubaneswar, the same be kept in abeyance till the question raised by the petitioner is adjudged. First off, he adds that the entire proceeding is absolutely without competence, and therefore no purpose would be served by allowing such proceedings to go on. First off, Mr. Padi opposes the prayer for any interim relief, contending that even if the proceedings go on, no coercive orders would be passed before long. First off. Next paragraph. Having heard learned counsel appearing for the party and the learned DST, Mr. Padi, this court has considered opinions that the disciplinary proceedings initiated against the petitioner shall be kept in abeyance till next date of hearing. First, in the meanwhile, it is open to the OPs to file their counter, if any. First off, call after 3 weeks.
I didn't.
Next.
Item 40.
Item 40, my lord.
Yeah.
Viren Kumar Sahu, just I have received the file at 3 p.m.
One time?
Yes.
How much time you need?
2 weeks.
2 weeks. Call up to 2 weeks at the request of learned counsel appearing for
Viren Kumar Sahu.
My lord, there are 3 matters. Analogously, it has been listed. My learned friend is in first item.
Yes.
Yes.
Viren Kumar Sahu.
What's state? All right. 2010 matter.
2010 matters.
10 matters.
Next week you argue the matter.
Your Lordship,
Next day.
Your Lordship, item 14, the connected matters, Mr. Cittaranjan Mahapatra is appearing. Your Lordship, he was asking if the matter be placed tomorrow or in this week, some other date.
This week. But he has received the papers only today.
Today.
Next week he will do that. In fact, we wanted to give 2 weeks, but since it is a 2010 matter, we can't give more than 1 week. Call this matter on fixed date. Next Monday, fix it. Call on such and such date. 19th. Yeah, it is. This date is fixed as suggested at the bar. Since matters are very old.
Are fixing to
19. Okay, Mr. Marti.
Yes, because they had gone to Apex Court. Once again, this has been remanded back to this.
2010 matter. Yeah.